Yes.
My lord, please, what's the statement again? Your network is breaking. I didn't get it.
I said you should start with Oscar Osarumi Omunamure. NICS stroke, CS stroke.
Okay. Yes, my lord. In this version, April 28 preceding. Suit number NICN 2023. Osaru Wunse and 1. Lapo staff multi-purpose corporation. 2. Lift above poverty organization Lapo Limited under the name and sign of Gladin Lapo Agri Development Limited. 3. Alfred Obo 4. Akim Kenbo. My lord, the parties are all absent.
Clement is present. Yes, my lord.
The plaintiff is also present.
Who is present?
My lord, the plaintiff is present. Oscar.
I am present. Is present.
Appearance. 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 I can't see your face. You have to on your video.
On your video.
Want me to record you? Yes, appearance.
My lord, CAC Efife for the claimant. CAC Efife for the claimant.
Yes. Yes. Any other appearance? Any other appearance? Registrar, have you served the defendant?
Yes, my lord, I did. They were all part in the...
Yes, counsel. Counsel for the claimant.
Yes, my lord.
You are still not on.
Yes, counsel.
Yes, my lord.
Mr. Epipi.
Yes, my lord.
Mr. Epipe.
Yes, my lord.
I can't see your face. You should be showing your face. If you want to appear, you appear properly. Not you show your face and you go away.
My lord, I'm showing my face, only that the network is not steady. I'm showing my face, my lord.
This case is for ruling.
Yes, my lord. My lord.
In my ruling, but unfortunately, I discovered that there is need for you to address me over my ruling. I need to be addressed. If I deliver my ruling, it may jeopardize your case. But after listening to you on jurisdiction, if I said I don't have jurisdiction, then I can transfer your case to up. But if I now deliver the ruling, so you address me on jurisdiction. You address me on jurisdiction before I deliver my ruling.
As a
deliver my ruling together with the ruling on jurisdiction. So I give you 2 weeks within which to file your. Listen. yourself. You should mute yourself. Unless you want to talk, you should mute yourself. You can only unmute yourself when you want to talk.
As the court pleases.
Instead, you will address me on jurisdiction. You have 2 weeks from today to file your written address on jurisdiction, and you serve it on the defendant, and they have 7 days within which to reply. If they have not replied, then we go ahead and take your own, and I will deliver my ruling. Registrar, give me date 3 weeks from now. When will it be? Registrar.
Yes, my lord. I muted myself. I'm sorry, my lord.
I need a date. I'm giving the claimant 2 weeks to file his written address on jurisdiction. Then the defendant 1 week to file their reply, if any. So I need date for hearing of for adoption of for the adoption of the written address on jurisdiction.
Okay, my lord. May 25. It's a Thursday.
This matter is for ruling. However, in the course of writing my ruling, I discover that I may not have jurisdiction to entertain issue of loan, that is the substantive issue before the court. In the circumstances, parties are hereby ordered to file addresses on whether this court has jurisdiction to entertain this matter. The claimant is hereby given 2 weeks within which to file his written address on jurisdiction. Upon service, the defendants have 7 days within which to file their own reply, if any. This case is hereby adjourned to 25th day of May 2023 for adoption of the addresses on jurisdiction.
As the court pleases.
Call the case,
As the 25th, 20.
Okay.
Call the other case for ruling.
Yes, my lord.
Yes,
my lord.
Barrister Monday Silvanus.
Yes, my lord. Suit number NICN CA 14-2019 between Barrister Mode Silvanus Model and Cross River Broadcasting Corporation, CRBC. 2, Civil Service Commission, Cross River State. 3, Accountant General, Cross River State. 4, Government of Cross River State. 5, Attorney General of Cross River State. 6, Radio, Television and Theatre Artists Workers Union, Ratawu. 7, University of Calabar. 8, Patrick Oga. 9, Dr. Williams Ekbekim. 10, Mr. Ntiga Ita. My Lord, the parties are all absent.
Appearance? Any appearance? Any appearance?
My Lord, the claimant lawyer called yesterday. He said he doesn't have an Android phone to connect, that he will get the ruling when it's delivered.
Okay. This is the ruling of the court. This is an application dated 20th day of February 2022 and filed on the 3rd day of March 2022 by the claimant applicant, wherein he phrased for one, an order extending the time within which the applicant may file and serve reply to the fifth defendant's statement of defense. 2, an order deeming as properly filed and served applicant appropriate fees having been paid. And 3, and for such further or other orders as this honorable court may deem fit to make in the circumstances. The application is supported by an 8-paragraph affidavit sworn to by the applicant himself. A written address was filed along with the application. Mr. Mode Silvanus Modef, who appeared for himself at the hearing of the application, relied on the deposition contained in the affidavit in support and adopted the written address as his argument. In the written address, a sole issue was formulated for determination, to wit, honorable court is invested with discretionary power jurisdiction to grant this application. In arguing the sole issue, Mr. Modeb submitted that ill health is the reason for delay in not filing reply within the period as stated in paragraph 3 of the affidavit. In support, it is submitted since the applicant has complied with the precondition before bringing this application. The court should the court is invested with power to extend time for the applicant to file and serve his reply to the first to fifth defendant statement of defense. It is submitted granting extension of time is an exercise of discretionary power of the court, which must be exercised judicially and judiciously. It is also submitted that the court has no reason to refuse applicant's application where the applicant has fulfilled or satisfied the provisions of the law. In support of this contention, reliance was placed on the case of Williams versus Hope Rising Voluntary Fund Society and that of Mohammed versus Duriminia versus COP. In concluding his submission, counsel urged the court to grant the application as prayed in the interest of justice. Ama Epo Esquire Counsel, the learned Deputy Director of Civil Litigation, Ministry of Justice, Cross River State, representing the face-to-face defendant in her oral adumberation, submitted that ordinarily she would have not objected to the application, but wish to point out that the reply was not proper reply to statement of defense. Counsel at the end of argument submitted that it leaves the issue to the discretion of the court. Court decision. I have issued, after issuance and service of the general form of complaint on the defendant, the next things to be done before commencement of trial is entry of appearance and filing of statement of defense. Thereafter, the claimant will file reply to the statement of defense, if any. When these processes are filed before the court, parties are said to have joint issues. The court as well become aware of the reality of the dispute between the parties. The parties also knows a party also knows his opponent's case against his will, against his. This foreknowledge of will help the court to know what it will have to determine at the conclusion of the trial. And in the second instance, it will enable each party to prepare and meet the adversary's case. Thus, see the case of Nobi versus Picolati, Far West JSC and CZNWAS. The essence of pleading is to enable the court and the parties to know from the joinder of issues the exact case which the parties have to make. There are three different types of, there are three non-different types of pleadings, main types of pleadings. They are the statement of claim, the statement of defense and reply. And there are others which are not very common. It is to be noted that a reply is also a pleading, like in the case of statement of claim and statement of defense. A reply being a pleading must meet the requirement of pleading for it to be properly before the court. One of the fundamental stipulations regarding nature of the statement of facts that should be made in the pleadings in the reply is that it shall contain statement of material facts and not law. Therefore, a party filing a pleading, whether it is statement of claim, statement of defense, or reply, must ensure that material facts are stated in that pleading. See the case of Attorney General of Anambra State versus Onuselga, reported in 1987 for Nigerian criminal reform. A hard look at the reply to which the claimant applicant is seeking for extension of time to file reply will show that the reply is a breach of the rules of drafting and filing of pleading, as the said purported reply is an argument presented for determination of issues. An address can only be filed at the conclusion of trial with the sole purpose of helping the court to know the position of each party in the suit concerning the issues raised by the pleading based on which the trial was conducted. Material facts are those facts in the pleading that must of necessity be stated concisely to establish the course of action. There is therefore insufficient materials in the reply as argument supported by law, and cases are not material facts. A dispute are always based on facts and not law. Law is only applied to facts. A party is not allowed to state law in his pleading, as the rule is that a party should state only facts and not law. Purely legal contentions must not be pleaded. A party is not to plead law, but the facts on which the law can be based. See the case of FCDA versus Noibi. See also Okenwa versus military governor. See also Onomade versus ACB. Parties are free to rely on whether legislation, legal notices, and or other laws they consider helpful to their respective causes without pleading such law. See the case of metal construction versus Abodere. It is also cardinal principles of pleading that it must be divided into paragraphs. The materials fact which constitute pleading should be divided into paragraphs numbered consecutively, with each paragraph containing as far as possible separate allegations. In pleading, there ought to be a separate paragraph of every distinct matter, and every paragraph must be sufficient, must contain sufficient information. See the case of Essin versus Matzen. It must be noted that the fact that pleading, the facts in the pleading shall be alleged positively, precisely, and distinctly, and as briefly as is consistent with the clear statement. Clarity and precision are some of the hallmarks of good pleading. The sentences should be direct, blunt, and unambiguous, and indicative of mood, which is ideal for making assertions. The use of passive voices, active voices, giving more positive, straightforward, and direct. Reply is not necessary if the purpose is just a mere denial. Reply is used to answer allegation which a defendant must raise as a plea by way of confession and avoidance, as it might have been. In the case at hand, the reply as it is not a reply, as it does not contain material facts, as I pointed out earlier. It is an argument presented in a form of an address by counsel. It does not meet the requirement of reply. In the circumstances, the said reply is hereby refused. The application to file that reply out of time is hereby refused. As even if I grant the application, there is nothing to say that is a reply that is before the court. The ruling is entered accordingly. I make no order as to post.
As the court pleases.
Give me date for hearing.
My lord, June 8th.
Registrar.
My lord, 8th of
Give
June.
Give me date.
My lord, June 8th.
8th.
June 8th. My lord, June 8th.
Okay.
8th of June.
It's okay. I hear you.
Okay, my lord.
This case is hereby adjourned to 8th of June 2023 for hearing. Hearing notices to be issued and served on all the parties. Proof of service to be kept in the case file.
As the court pleases.
Call the next case.
Okay. Number NICN. Suit number NICN CA 16-2023 between Dr. Bassi of 4 and 1, Government of Cross River State, 2, Attorney General and Commissioner for Justice, Cross River State, 3, the Commissioner for Lands and Urban Development, Cross River State. My lord, the parties are absent.
Appearance. You have to unmute yourself, counsel.
With profound humility, my lord.
Yes.
D.B. Ariko.
D.D. Ariko.
With D.B. Dixon Bassi Ariko, Esquire. My lord, appearing with Ofem O. Mbang. My lord, will appear for the claimant who is present in court.
I'm present.
Who is present?
The claimant is present in court, my lord.
It's all right. Yes. Any other appearance?
Okay.
Registrar, have you served the defendants?
Yes, my lord, they've been served, including the enrollment order, my lord.
Any proof of service?
Yes, there's proof of service in the file, my lord.
Okay. Yes, Mr. Ariko.
My lord, the matter today is for motion on notice. which have been served on all the defendants. My Lord, the motion on notice was filed on the
Yes.
18th day of April 2023.
Yes, Mr. Aliko.
Yes, my Lord. The motion is brought pursuant to Order 17, Rule 1.
Yes.
And Order 22, Rule 1 of the National Industrial Court of Nigeria Civil Procedure Rules 2017.
Yes.
And under the inherent jurisdiction of this Honorable Court, my Lord.
Yes.
My Lord, the motion has two prayers.
Yes.
Yes, my Lord. My Lord, prayer 1 is for an order of interlocutory injunction.
Yes.
My Lord, we have trained the court to restrain the defendant's respondents, whether by
Yes.
themselves
Yes. Yes.
whether by themselves, workmen, privies, or others, howsoever called, my Lord,
Yes.
from evicting, selling, dealing, or interfering with the possession of the property described as House A1, the subject matter of this suit. My Lord, in a manner inconsistent with the possession or interest of the claimant applicant. My Lord, pending the hearing and determination of this suit.
Yes.
My Lord, the second prayer is the omnibus prayer for such further orders as this Honorable Court may deem fit to make in the circumstance of this case.
Yes.
My Lord, there are further grounds. There are grounds upon which this application is brought.
Yes.
My Lord, one of them is that the property, the subject matter of this suit, is the official residential quarters of the applicant, which is referred to as House A1, Doctor's Quarters, Calabar Municipality. My Lord, the applicant became chief of this house officially and was formally allocated to him by the government.
Yes.
Yes, my Lord. My Lord, the defendant proceeded to publish in a newspaper that they want to sell the house. On a Chronicle newspaper, yes, my Lord. My Lord, the defendants are very surreptitious. They are cunningly trying to deprive the applicant from the purchase of this house, which is his official quarters.
Yes.
My Lord, the policy in existence is that where an occupier of a government property like that is in possession, he is entitled to the benefit of the first option to be offered or allocated to him.
Okay.
My Lord, this the defendants are trying to avoid, and they want to sell the house to a different person unknown to the applicant without following the due process. My Lord, that hence this case. My Lord, we are praying the Honorable Court to grant this interlocutory application pending when my Lord will hear the facts and evidence in this case and determine it one way or the other.
Yes.
My Lord, while we came with the interim application by way of ex parte,
yes,
and yes, my Lord had directed that we should proceed towards service of the motion on notice, which we have done. My Lord, while we had done that, in the public holiday of Idigbe,
yes,
they went behind in a crowd, went and planted beacon stones, even when they were conscious of the existence of this case. My Lord, there were many.
And did what? They did what?
My Lord, they planted beacon stones on Friday, the 21st, on a public holiday, the first holiday of Idigbe. The defendants, especially the third defendant, the agents of the third defendants went there and unwittingly planted beacon stones in that property, the subject matter of this case.
Yes.
My Lord, it shows their actions, their intentions, that if this court does not stop them, before we conclude this case, my Lord.
But that evidence is not before me, that they went on Friday and planted bacon stone. It's not before me.
Yes, my Lord. My Lord, that was after we had come before you by way of ex parte. And my Lord
that doesn't mean you shouldn't file further affidavit. Why should they have make you to file further affidavit? You should have filed further affidavit stating those facts.
My Lord.
Because I can't rely on your submission on that.
Yes, my Lord. My Lord.
It's evidence. It has to be from a witness or from affidavit, not from the mouth of the counsel.
Yes, my Lord. My Lord, on the day my learned friend of Mbang moved the motion ex parte, my Lord had directed down there in one of the reliefs that all parties shall not do anything to frustrate the motion on notice.
I'm not saying I have not said so. Wait, that is another thing. And it is another thing for you to file further affidavit. The mere fact that I said they should not do anything. If they went ahead and do anything, there is left for you to cite them for contempt.
As God pleases.
That one is left for you to cite them for contempt for what they have done, or even to ask the court to make an order for them to reverse what they have done.
Thank you, my Lord. My Lord, we thought it wise to bring it to the notice of the court to the extent that, except they are stopped, they will proceed.
What I'm saying is that evidence, it cannot come from the mouth of counsel. It's an evidence that has to be from a witness.
That's God pleases.
In an affidavit.
That's God pleases.
You have time. You should have filed further affidavit. You said they did what they did on Friday, and today Friday, 7 days. What have you been doing? Within the 7 days, you have not filed anything. You should have filed further and better affidavit intimating the court. This is what they have done. You should have filed. Yes. Any other?
Stop, please. My Lord, in support of the motion on notice, it's my Lord, an 18 paragraph affidavit.
Yes. Yes.
18 paragraph affidavit, my Lord, with my Lord, with
Yes.
five exhibits attached to the affidavit.
Yes.
Exhibit A to E.
Yes.
My Lord, we have in support a written address in support of the motion on notice, sir.
Yes.
My Lord, we rely on all the paragraphs of the affidavit and the exhibits attached.
Yes.
My Lord, we adopt the written address as our argument in support of the application.
Yes.
My Lord, we pray that our reliefs be granted. My Lord, let the rest be protected pending the determination of the case.
Yes. This case hereby adjourned 25th day of May 2023 for ruling.
Ask God, please.
Hearing notice to be issued and served on the defendants.
Ask God, please. We are grateful, my Lord.
Yes. Registrar, call the next case.
Yes, my lord. Suit number NICN CA 01 2020 between Mr. Oka Michael Obona and one Cross River Institute of Technology and Management, UGEP,
You are still in God now, we never rise.
State. 3, Attorney General and Commissioner for Justice, Cross River State. My lord, the parties are all absent.
Appearance. 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 Council, increase your volume. Increase your volume. I'm not hearing you. Yes, appearance. Yes. Appearance. Council, I'm not hearing you. Yes, appearance. Well, this matter is for judgment. I'll proceed to read my judgment. The appeals council is having challenges. Maybe at the end of the judgment, we may take the appearance.
As the court pleases.
Mr. Aripo, you are free to go. Mr. Aripo, you are free to go. Yes, judgment. This is the judgment of the court by the general form of complaint dated 6th day of January 2020 and filed on the 7th day of January 2020, accompanied by a witness statement on oath, list of witnesses, list of documents to be relied on by the claimant. The claimant phrase as per paragraph 16 of the statement of fact as follows. 1, a declaration that the termination of his employment contained in the letter dated 7th day of October 2019 is null and void, having not been complied with the contract conditions of service. 2, an order setting aside cancelling the letter dated 7th day of October 2019 for same being in violation of the claimant's right to fair hearing. 3, a declaration that the claimant is still in the employ of the dependent. 4, an award of 610,000 naira being claimant's unpaid salaries. 5, award of 5 million cost. 6, an award of 200,000 naira cost. In the case of the claimant, stated that he was initially employed by the first defendant as part-time lecturer prior to his conversion in the civil engineering department as an adjunct staff. Following complaint titled "A Call to Rescue CRITM," the claimant was suspended by a letter dated 7th day of February 2019 with the title "Academic Program Restructuring." At the end of the second semester, the claimant was not recalled. In line with the position, he wrote a letter dated 8th day of July 2019. But instead of recalling the claimant, the defendant terminated the claimant's appointment. Aggrieved by the termination, the claimant approached this court for redress. The defendants have filed their statement of defense, list of witnesses, a list of documents to be relied on at the trial. According to the defendant, the claimant was engaged as part-time lecturer prior to his conversion to an adjunct staff civil engineering. The claimant had never been a full-time staff of the first defendant. The claimant is not still in the employment of the first defendant, as his employment was terminated through the letter of 7th day of October 2019 titled "Academic Program Restructuring." The defendant denied being in possession of letter from claimant titled "Rescue CRITM" dated 7th day of February 2019. The termination of claimant's employment was because his services were no longer required. The claimant's salary The claimant employment is governed by his letter of employment. During the period he served, he was never queried, nor was he asked to appear before any disciplinary committee. The submissions of the defendant, Likon Akuye Esquire, State Council 2, Ministry of Justice, submitted twin issues for resolution. They are: 1, whether the claimant's employment has statutory labor entitle him to the rights of a permanent staff. 2, whether given the evidence of the claimant he has provided his case to entitle him to relief sought. Argument on the issues have been captured in the body. Skip reading the argument of counsel. Likewise, the defendant, the claimants have all made submissions, written submissions. The law is tried. The claimant insisted that his contract of employment with the defendant is one with statutory labor. I have considered the processes filed, the evidence laid by the parties in the course of trial, the final addresses and oral submissions of parties. Let me start with the submissions of the defendant in their final written address to the effect that the claimant did not file a reply to the amended statement of defense dated 3rd day of November 2020 and filed on the 16th day of November 2020. The presumption is that claimant is not contesting the abandonment in the amended statement of defense. The defendants initially filed their statement of defense to defend the defense dated 2/6. The defendant initially filed their statement of defense dated 26th day of February 2020 on the 27th day of February 2020. The claimant reply to the statement of defense was filed and received at the registry of this court on the 29th day of June 2020, and the processing fee paid. On the 10th day of July 2020, the law is well The law is well settled that the amendment takes effect from the date of court. The initial processes was filed before the court. In view of this, counsel misconceived the laws by submitting that there is no reply to the statement of defense. The amended processes takes effect from when it was initially filed. This means there is a reply to the amended statement of defense already before the court. I find no merit in this. I will deal with another simple but fundamental issue which parties differ. That is whether claimant's employment is one invested with statutory labor. The claimant insisted that his contract of employment with the defendant is one with statutory labor, while the defendant is of the view that the employment of the claimant is one that is at the pleasure of the defendant. The law is right for an employment to enjoy statutory labor. The manner, employment, and termination must be specifically provided for in the rules. However, it must be noted that the mere fact that the employer is creation of statute, or that it is statutory corporation, or that the government has shares in it, does not elevate its employment into the status of statutory labor. Rather, there has to be a linkage or nexus between the employee's appointment with the statute creating the employer and the corporation. In fact, it has been held that the fact that an appointment is pensionable or made by statutory body does not mean that the appointment enjoys statutory protection. or in one is one that has statutory labor. See Imolome versus Wayek, see Jigba versus UBN PLC, see Nefa versus Adesoja, see also Ilobachi versus Phillips. It is now tried that condition of service which gives statutory labor to a contract of service cannot be a matter of inference. There must be condition which expressly set out by statute that the rules of requesting now whether the employment of the claimant is this case is temporary, part-time, or full-time is of no moment. What is important is the nature of the employment, whether it is protected by statute. The first defendant in this action was established by the Cross River State Institute of Technology and Management, UGEF. The first defendant in this action was established by Cross River State Institute of Technology and Management, UGEF law of 2012. The law has expressly made provisions for employment and discipline of members of staff of the first defendant. Section 22 makes provision for removal of employee on ground of misconduct. The section conferred on the council the power to make regulations that will govern the conditions of service of its employee. Having regard to the provision of Cross River State having regard to the provisions of the Cross River State Institute of Technology and Management, law number 4 of 2012, the principles of law enunciated above on the statutory level, I have no hesitation in coming to the conclusion that the claimant's employment in this case has statutory level as it is protected by the law, that is the Cross River State Institute of Technology and Management Studies. With the above finding, where a servant is to be removed in a contract with statutory labor, the first question the court would ask is, has the servant's employment been determined in accordance with the way and manner prescribed by statute, or is the contract governed by the agreement of the parties and not under any statute? Thus, where the servant is sought to be removed in a contract with statutory labor, that is a contract of employment wherein the procedure for employment and discipline have been stated. Such a contract must be terminated in the way and manner prescribed by the statute. Any other manner of termination which is inconsistent with the relevant statute is void and has no effect. Any other manner of termination which is inconsistent with the relevant statute is void and has no effect. In other words, in an employment with statutory labor, the employer must comply strictly with the provisions of the law. Any other manner of termination of employment which is inconsistent with the network in case Any other manner of termination of employment which is inconsistent with the status null and void. See Bamboy versus Unilorin, see NISA versus Council, NISA Council, see Controller General versus Busso. In cases governed by agreement of parties and not by statute, removal of a servant by termination or dismissal would be in the form agreed to any other form of dismissal or termination cannot only wrongful termination or dismissal. It therefore does not warrant a declaration of such dismissal as void without any reason. Employment of a servant. I shall now determine the case as put forward by the party. It is well settled that claim are prescribed by the reliefs being sought by the claimant before the court. It is the duty of the claimant or plaintiff to adduce such evidence that are sufficient to prove the case against it. In the circumstances, I shall now consider the reliefs. Reliefs 1, 2, and 3 are interwoven, they are related, they will be taken together. In these reliefs, the claimant is seeking for declaration and nullifying the termination of his appointment, setting aside the termination and declaring claimant is still in the employ of the first defendant. According to the claimant, an employer can terminate contract of employment provided the terms and conditions of service between the employer and the employee according to the claimant Exhibit D, contract of service has provided the duration of notice to be given, the circumstances upon which claimant's employment can be terminated according to counsel, the payment in lieu of notice. It is submitted by the claimant that he has not been given opportunity to defend himself before his appointment was terminated. It is also submitted that the termination is in breach of the contract of employment. For the defendant, claimant is capitalizing on a typographical error on term months to 2 months salaries in lieu of notice. Counsel asked the court to use literal rule of interpretation It is also submitted that there is no disciplinary proceeding and the suspension did not arise from misconduct. In an action where the claimant is contesting validity of his termination of employment, he has the onus of establishing the terms and conditions of the contract, as well as the conditions, those conditions that were violated by the defendant. It is in the instance of the case the conditions of such as pointed out earlier in this judgment, claimant employment is one with statutory labor. In the circumstances, any purported termination to be valid for any purported termination to be valid, it must be shown to have been done in line with the conditions of service, Exhibit D and H. In Exhibit D, it was stated either party may terminate by giving monthly notice or by payment of cash equivalent. The first defendant has also the right to terminate the claimant employment for failure to meet up with the job or by violating any of the rules of the first defendant. Under Article 6.9A and B, possession were made for termination of employment on ground of recognition. It can be deduced from the holistic reading of Exhibit A, B, C, D, and D that the termination of claimant's employment can be attributed to alleged restructuring in the circumstances the defendant is mandated by the provisions of Article 6A and B of Chapter 6 of the Conditions of Service Exhibit H to pay the claimant 3 months salary in lieu of notice of his and his cumulative leave commuted to cash, and in addition, 25% of his annual emolument. The defendant did not pay the claimant the requested 3 months salary in lieu of notice as the defendant did not pay the claimant the requisite 3 months notice in lieu of notice as required by staff handbook. What the test defendant did was in Exhibit A, ask or request the bursar, request the author of the test defendant to pay claimant 1 month salary in lieu of notice, where there is conflict between letter of appointment and provisions of condition of service. The conditions of service prevail. Therefore, in the instant case, the claimant is entitled to 3 months notice in lieu of notice. The defendant, having failed to comply with the laid down procedure for terminating claimant's employment, the entire exercise is null and void and of no effect whatsoever. From all I have been saying above, the claimant has proved that the termination of his employment by the first defendant or relief for which is for payment of the sum of 610,000 naira relief for payment of the sum of 610 unpaid monthly salaries following stoppage of claimant's employment has no legal basis, as the claimant is entitled to the fund of his unpaid salaries in the sum of 610. For avoidance of doubt, the orders of the court are as follows: a declaration is hereby granted that the claimant's determination of the claimant's employment did not follow due process. A declaration is hereby granted by the claimant. The termination of claimant's employment via letter dated 7th day of October 2019, Exhibit A, is null and void and of no effect. B, a declaration is hereby granted to the effect that the claimant is still in the employ of the defendant. 3, the claimant is entitled to his unpaid salaries from January 2019 to September 2019. The claimant is not entitled to damages in the sum of 5 million naira, as same will amount to double compensation. The declaration is also hereby granted in the event that the claimant is still in the employment of the first dependent. The claimant is entitled to his unpaid salaries from January 2019 to September 2019 in the sum of 549,000 naira. The claimant is not entitled to damages in the sum of 5 million naira as compensation, as this grant of that relief will amount to double compensation. The claimant is entitled to cost of this suit assessed at the sum of 200,000 naira. Judgment is entered accordingly. Yes, counsel. Can you talk now so that I can record your appearance? I can't hear you. Yes. Use one device. It's better to use one device. Yes. Counsel, I I can't hear you. I have delivered my judgment.
As the court pleases.
Registrar, any other matter?
No, my lord, that's all, my lord.
Okay. Okay, thank you. Have a nice day.
Thank you, my lord.
Bye.
Bye, my lord.
Okay.
And the provisions of the conditions of service.
No. So you cannot make this one.
The provisions in the conditions of service are even they're different from
Yes.
the provisions
Because
in
if you're coming from
this
here,
handbook that the claimant himself relied on.
Wait, the conditions in the handbook are different from the
conditions
conditions
in
in
the
the law.
And the
But this
claimant
one should be
relied on the
superior.
handbook.
It is the handbook that should be superior.
No,
isn't
no,
it?
no. This
Where
derives
there's one-
from the law.
The authority to do this one, the rest
From
He
the law.
cited one authority.
And this one is
that
doesn't
the
even
law
work in
will
his
prevail.
favor. This one does not even work. This one that he did does not work in his favor.
So the law that is not working in his favor that he did not even rely on, and the court can the court do the case for him?
cannot close the
Yes,
eye.
the court cannot close his eyes.
The court cannot close the eye because one, remember we are saying the employment. is not-
Me, I'm seeing grounds of appeal everywhere.
No, see, me, I'm looking at it from another angle. Now, the powers to make the guidelines are from the law.
Yes.
So they went ahead and made it. But must is there any rule that it must be?
No, there's a
as-
law.
There were provisions in the law.
If they prevail,
Contrary.
so if they are contrary, the law will
Because this one is like.
The law will prevail.
The law will
Because this one is considered it.
Yeah.
In my mind, what
It's just that
I was
this
seeing
is
it like,
not-
I was seeing it like one person made two decisions. So the later decision should be
No,
superior.
no.
Since they made the law and they still made
we don't even know which one is later.
This one is made by the House of Assembly. This one is made by the Governing Council of the State.
The law prevails.
It's the judge that did this matter. It's the judge that did this matter for
And the
them.
court do not have prevail.
It did not do
What is
that.
what is
That's
correct?
Cannot
They
cannot
say
close
no.
the eye. No.
They say no.
Yes.
But then we are saying, Judge, as we give it, as we bring it before
You
you,
look at only what
don't look at what was, don't look at the law. Keep the law
And did
aside.
you raise the law yourself?
the law does
Nobody
not work
raised
in our favor.
So you did not raise it.
I
So
think
nobody
I
raised
think
it. He just
even
he
he
just-
see, I'm saying the document he relied on does not favor him. These guidelines he relied on, you know, when he talks about who is an academic staff, it doesn't favor him at all.
And these guidelines help us to resolve that month's notice.
Yes.
As 1 month notice. But like that law says
And
specifies 3 months.
So the judge is now saying he's entitled to 3 months. While he said he's entitled to, he didn't say.
because the
it.
conditions of service were made for inferior, as in because there was an established. But most times, conditions of service is always when there's a gap in the law.
It depends when was this one
That's
even
what
made?
I.
Is this thing dated so that we'll even know? For that law, I think it's 2012,
Yes.
if I heard very well.
Okay.
So it's possible that this one was in existence there
And
before they now passed.
there's
it.
no way we would have started going to law because
How will we know the
You
date of
know-
this thing? The claimant did not plead it. Abi,
Okay, people
There's
look
no
at
way
it,
we-
but yes,
we didn't even
we
look at
didn't look
it.
at it. We just
We
relied
just
on
assume that this
This is what he said. regulated, and this is what he said regulated.
Yeah.
So relying on this, we're able to say, look, even this thing you're relying on does not work in your favor. Now the judge has left this one entirely. And this was a 1 month notice. So the issue was whether we gave a month notice. Now the judge is saying, look, there is a law, and the law says 3 months notice. So he's entitled to 3 months notice. This is something that the claimant himself will not even.
Can't we argue that this man did not plead and prove the terms and conditions of his own employment?
No.
When the terms were before the court.
How were
Then,
they-
no, I think what she's trying to say is that the law that the judge relied on was not even pleaded by the claimant.
Can't we- And I know that in a contract of employment, the claimant must plead and prove the terms and conditions of his employment. If he went and brought something else that is not the terms and conditions of his employment,
No,
can we say he has
the
pleaded
issue
and
was-
proven his own
Is
worth?
it statutory? It was
Was
when
this
a one
employment
on statutory flavor. How do you determine that?
Look
By
at the
looking
law.
at the
By
law.
looking at the character of
Me, I'm thinking of grounds for appeal.
No,
And I'm now
no,
thinking now.
no, you are thinking of the class of appeal.
Mm.
Wait. Are
Can it
just
be said that the
are you
claimant-
just appealing for appealing's sake? Or
The
you
thing
are
I'm talking is not law.
And this
I understand what
You
you
understand?
That's
What
what
I'm saying is not law.
what-
Am I saying something that is not law? Can it be argued that the claimant has pleaded and proved the terms and conditions of his own employment by the case I put forward before the judge?
No, the question now is whether a court can raise an issue of law like suo motu. That's the issue. Whether the court can separate
I
law.
don't,
You can't say that it's true because the issue of that flavor came up.
So he
was
told you
not-
that-
So the question that comes to the government is
Which
statute.
statute? Yes.
Is statute.
Mm.
This school that is
So
there
whether or
statute.
not anybody
And that
pleases,
is
you
why-
have to have
That is
recourse
why
to the statute.
this is why that is why I have to look for the law. And unfortunately, there's a law.
Which
So that would be the claimant's
the one
answer.
I relied on.
Yes.
I said I did not rely on any law. That what we had was guideline, and it was tendered by the claimant. She kept talking, and I was like,
But I'm learning something here. I was always so sure that where there's law and then conditions of service, the conditions of service will be, because in that College of Health, okay, except the law
They law
specifies that.
exactly. The law specifies this thing as well.
Okay.
So it's not like a conflict between the two.
Yes, or the law specifies that the subsequent contract of service should supersede whatever general provision. Do you understand? Like our civil service rules says it should apply to anybody except there's a specific conditions of service.
Okay.
So that means in that case now, even if civil service provides something, if that condition, yes, that will
I like that, like college of health.
Yes.
Why school service? Timing is 35 years of service or 60 years.
Their own is 65
years of
yes.
age.
So the claimant is still in their employment.
Yeah. And so much money. Did I hear that 5 million naira damages was truly granted to them?
No.
General damages. Double compensation. And then the 200,000 for cost of litigation is granted. Is there no rule about court not granting cost of litigation? I heard something like that.
No, it's not. The court has discretion.
Okay, on that one
It
too.
is when you are claiming for litigation, the legal practitioners
So you will not pay that special.
and then you see that
That's when
that
they
is when you
go
must do it. But the court that after the whole case award the cost.
sorry, I said
Let them
that
come and
again.
collect
Take that.
We know they fear money.
And then this one, sorry, I'm taking it back. But the amount he mentioned as the salary is different from the 510 that they claim.
You know the judgment.
I mean the 610.
No, that's what.
The 610.
Yeah.
Okay. I thought I had 500 and something.
Cumulative.
Instead of 600.
For that period where it was. Isaac, take what you were saying.
And he did not say until now. Now he has not been reinstated. I mean the claimant did not say from
the
them.
employee. He's still in our employment. That means it's until now.
No, until that time now. Yeah, it's like from when he was suspended to the July when he instituted the matter. But he did not say.
You mean the claimant's claim?
Yes,
What
now
the claimant asked for.
an award of 610,000 being on payments on paid salaries of 10 months from January to September 2019 and the July salary of 2018.
That's all
So
the
my
claimant is
question
asking
is,
for.
yes.
Now, my Lord has given him till today.
It may not be today. That's why I'm saying 610. That was the confusion.
Yeah, this
No, he
the
awarded.
amount. He awarded this amount.
Okay.
He awarded
This 61,000 per month till now. So when is reinstated?
no,
And then the entitled to his unpaid salary. If he's still in employment, what is unpaid salary? Still today now.
My own is that he pays an amount. That's why I'm thinking this amount is for a specific period.
Can be paid when he
You know what? There are many things.
Okay.
because
Statutory flame, unemployment is statutory.
So now they argue that the reason why it did not work is because of us.
We
He
didn't
was
give him
ready
the
and willing to
opportunity.
work. We did not give him the opportunity.
Yeah.
This is our lawyer. The case.
Isaac, sorry, you were saying
There are
something.
many questions.
You were saying something about cost of action.
the cost of action, the court can award the cost at the discretion, even under the rules to award cost. But when you are claiming for the money you paid your lawyer in the case, that is professional fees.
Okay, so if you had said 200,000 professional
Fees or legal fees, yes.
that's where he needs to
To prove.
But
Okay, so we just said
award
So
cost.
if
Okay,
it generally
just
says
an award
cost of,
we can't.
Just a cost of
you know, this is a matter of semantics. Why is it without due respect?
No. So what Isaac means is if you institute a suit for your specifically for your litigation fee.
No.
That they claim.
Include that in one of the claims. That's what it says.
He said that you say the court can award it.
If it's cost of litigation, the court will award without specific, yes, or more.
The amount asked.
Or if it's a legal fee or professional fees.
Okay, as part of your
I'm wondering why cost of
I'm not
litigation
even
would not even still require specific proof. Do you understand?
People have discretion to make an estimate.
Okay.
And I think he felt that 200,000 is fair.
It's fair enough. Yeah.
He has discretion to make estimates. Say, okay, this matter lingered for this long, the 5 processes.
All this one at the top, when they civil litigation, you is in appeals. She's already thinking of grounds of appeal.
Me, I'm learning. She's thinking of appeal. Me, I'm learning.
She's already thinking ahead now.
He has to do still you are ready for the who is going to sponsor the appeal? Can volunteer. This one. I
don't even like it.
Compare records time. The next
But the court has made our case with first.
Not really. It's not so now. There was law. And you are looking at it like a lawyer. You're not looking at it as a regular human being. That this man is actually entitled to his salaries, and government does a lot of nonsense things like this.
The man said is not wise. He's lucky. Look at the letter he wrote to the institute as an employee. He's a foolish man. And anyhow, he has paid some price. How would you go and you are a staff or you're an employee? Everything that is wrong with the institute that the DG is doing, you carry and gather people and write it through God knows who. How would they not?
Why didn't they remove him on grounds of misconduct? Why didn't they remove him on? Is there no provision for grounds of misconduct?
Them there's like they're not even aware of their own law.
They are just
they know about their rights.
I don't feel that
he's not. They don't feel he's not even a permanent staff.
And they didn't respond to what was complained. They just said, okay, let's do it formally. Like, okay, don't need to again.
And in that their institute, they have categories of staff. They are trying to sound like more like a part-time staff. You understand? And they did not feel that they need to give him any special treatment like their full-time staff.
And now their law is saying academic, whether full-time or
exactly, did not distinguish.
Of course, initially I felt that
no place in that law was staff defined.
Yeah, salary.
You understand?
We will read that.
Now we will read it.
Is there anything
We have to find out law now and read it.
Isaac, are you hearing?
Because if I am employing people in different categories,
yes,
you will not
I'm
want
just thinking that law. Is there no place in that law where staff was defined?
Nobody talked about law.
No, I'm feeling like the law is a judge now. Now that it has been an issue, is there no place in that law that they define what staff means? So that we will know that staff did not include adjunct staff. Because now he's now saying the law says academic, as long as the academic, whether adjunct or.
And you know the attitude of the employment courts and those courts, they are sympathetic towards the claimant.
Yes, always. They are always sympathetic to the claimant. Always. Just as rent courts be sympathetic towards landlord. I don't know why.
Not tenant.
I thought it's landlord. That means the court generally looks at the weaker person. Yes.
Like consumer protection. Look at the consumer.
Yes.
Okay.
But sometimes these weaker people are more vicious, more terrible than the ones that others.
This APO would need that they are hearing up. And have you read that? Tenant held on to a landlord's property for 14 years and was dragging him up and down till the Supreme Court. 14 years is not parent. Me, follow you to Supreme Court. Go, come on in my house. I will throw you out. 14 years. Thank you.
Money man. The right time.
Am I waiting for you for the Supreme Court? Yes. 14 years. Are you doing? Without paying rent. We'll just be living there.
We had to stay here. This where we go to network. Okay. Get better.
They not define that.
It did not define that. Yes,
You not define staff. So we are going to ask from that.
The schools accept you. That's kind of God.
Who told you to see the law?
But Emma asked to call the Madam Virginia, read the law.
Okay.
So I kind of simple.
Okay. So the fact that staff, sorry, our staff, okay, finish. I'm always
Well, I didn't even know that was this case that the
okay. Our staff was not defined now. We should now assume that the judge is right. Everybody.
Yes, that's true. Since they just say that you are not that. If they are defined staff to say maybe full employee or blah blah blah, we'll just say that means even when they say that academic staff, it's not part of the staff. Let's be careful. That means even all these cleaners can
Do
just
you understand? If we have one law that gives everybody an equal definition.
Yes. You're not finding staff.
Just mentioned that there's no distinction.
Oh, you lost those people. That's why it's
everybody is having
Meanwhile, the employer is distinguished when employing them.
The claimant is not a full-time staff, it's an adjunct staff. So he was employed as an academic staff. So
ICM
of management.
Yes, your management.
So the court is now saying whatever applies to academic staff will apply to him. Meanwhile, our own case was that it's not even his employment does not enjoy statutory labor because it's not a full staff. Yes. But this was
Does he have a letter of
Yes. That specifies that he's an adjunct staff.
specified as that. You come to think of it. What about case law?
Think it very well.
What about case law? Case law defining who is staff is.
Okay.
How do you understand? What about
It's a
case
staff.
law?
There's no question about whether it's a staff. It's a staff. Because whether by being an adjunct staff, he does not enjoy statutory labor. Yes.
So now
Whether by being an adjunct
We'll now look for case law. Case adjunct staff to enjoy statutory labor.
I know when you're looking at you are looking at whether it is engaging him. You are bound to follow the due process.
Yes, that's it.
That's the first thing that the court decided.
Yes.
So in disengaging him, if we follow the process required by
And
the
it's even
law.
entitled to due process according to law. If
By
it's
the
not
law calling him academic staff, that means he's entitled. That was the first issue they got determined.
except you can find
If we think well, we will see.
no, but in cases like this, so if you find other provisions showing to the contrary, like showing that the legislators did not intend that an adjunct staff, you understand? Even though they are generally said academic, then it will be appealable now. Now to look that law well.
We will look that law. Because the institute.
But we can overstudy it now.
But the employer did not intend to treat certain classes of people as people with statutory.
Yes. Generally, an employer does not do that.
If it's a employer full-time staff, you understand? Yes.
The employer, who is the employer?
ITM will be a government of
This law is made by the house.
No, that's what we are saying. We will look at it, but we assume that it's one person.
The law.
So there's a lacuna in that law. In that law, they should have distinguished between adjunct staff, full-time staff.
No, but come
Not just one umbrella definition.
here. I'm just thinking generally. If it doesn't matter to the employers, why would they still specify that one is adjunct and one is if it does not matter?
And it made its way to the handbook. It made its way to the handbook. How did it not make its way to the law?
So
It made it from the letter of employment. It also made its way to the handbook.
There's a provision in the Evidence Act that where there's documentary evidence for the court will not look at any extraneous materials as interpretation. Except the exception I'm going to. Except there are other documents showing the intention of the maker of the first document that he intended an alteration. Do you understand?
So it can be argued that
I'm just thinking, if
Okay, do you know what?
why would they go ahead to
No,
specify some as
yes,
absence and
then
some as
employ
free?
some as
If
permanent.
they think also, yes.
The one was the of all the letters of convention, and which is tender.
Expressly
Thank you.
stating it.
Tender.
Yes.
Or is it only for retirement benefits that they made the distinction?
Tender.
I want to believe that it also
Wow.
would extend determination and other such benefits.
It has made us.
Now to look that law, sir,
I will look at
and
it.
case law,
You know, if
explain how in the usual course of practice, so do people intend that adjunct staff should enjoy all the, case law will show in the usual course of.
While looking at whether the actual staff will enjoy all these things. Now ask yourself, how is actual staff employed?
As is dismissed. It will still come down to the issue of statutory favor, and anyhow he will be enjoying his appointment or enjoying.
Because that procedure is
Because in this one, so there were procedures. It's just that the procedure is different from the law that the court now relied on, the actual law, but there was a procedure. So no matter the argument, right, his appointment will still enjoy.
the moment the issue of termination arises
And the law says how.
that procedure is what
It's a procedure that determines whether or not your appointment enjoys statutory favor.
No, that's why we are looking at if cannot adjunct staff should enjoy all of it.
There's the way you appoint adjunct staff. There's the way you dismiss adjunct staff in our own laws that we rely on. That means that adjunct staff appointment enjoys by specifying how it should be employed and how it should be
terminated. Okay.
Yes.
otherwise you will just say
Just employ him anyhow, no law governing. That means all these are cleaners.
That's what I'm saying. If we have a law that just says staff is staff.
So we should do our research. You get 5 minutes.
No. Even if it's not
Maybe
for
we
I was so
Yeah.
sure. I was so sure that where there's law and there's conditions of service, conditions of service always take superiority. What I felt is that I am the one saying this. It's like when Supreme Court overrides itself later. I said this today, I said this tomorrow. It's still me. So the one I take tomorrow, the later in time should be the one to prevail. That's what I thought. No, I had the power to do all of this. But from what he's now saying now is that whatever I say later, it will still be held very.
That's when the equities are equal. That's when the equities are equal. Those two papers, they are not standing.
They are not equal. Yes, you are right. But one is law. One is law.
the one that donated.
Where it's unequal, the law prevails. The law.
Except the law expressly provides that the other ones should override, like our civil service rules.
It's like the one authority to show which one will prevail.
I did, yes. I would love to see that.
When we read the judgment, it is something that they do every day. And it's so specific that the only employment, but it does not mean there are no grounds of appeal. No judgment will not get grounds of appeal.
Of course, they will always be done.
The thing is, let it be enough to,
sustain the appeal.
But you know how appeal can become about something different from the merits of the case. Completely different. And at the appellant becomes that problem.
And like now, what did he have the right to raise something that was not before him?
That's why I'm saying they are grounds of appeal.
No, but
Okay,
since this is law, yes, since this is law, you understand. You cannot say you should not have recourse to law. The law is at his rest. It's just like when two people are arguing, he's supposed to solve. So he can solve with whatever he chooses. But that, well, I don't know that.
Yeah, I think that we can argue that the chairman did not plead and put his own terms and conditions by relying on it.
Yes.
That is terms and conditions. His terms and conditions is not
And God is really acting as a Father Christmas right now. There's that provisions about that Father Christmas. Giving what he did not ask for. He did not ask for this according to the law you are praying. That's the truth.
One Mary was appealed that she printed. Claim and claim no one asked for anything, nothing monetary. The court gave her 5 million. How much? 24 million.
Why?
I say what?
Christmas.
Father Christmas.
You should not say you are not.
So, but I think
This one we are making
understand
us
what
something.
you
Thank you.
I think I understand.
That's
what
where
you're
my
saying.
mind, because me, I know that in
Nobody
employment, that, you know, remember, Lincoln was even saying, remember when she was saying, why did he bring this thing? I say, if he does not bring this thing, he doesn't even have a case. No matter what you come out, because you must plead and prove the terms and conditions of your
So the first bracket.
So by bringing these things that are not the terms and conditions of
It did not prove it now.
is
How
this
did
your
you just say
It did not prove. It did not mention the law at all.
what of the terms and
Got the
conditions?
terms and conditions.
Is this the terms and conditions of the employment?
That's the thing.
So at the end of the day, this is not the terms and conditions of it.
This is not the that's where
At the end of the
I
day,
think
at the end of the day,
The law.
Even if those
He did
things
not
are
bring
sent, according to the terms that
This
is
is
presented before the court, he was not, yes. So why how did the court go to bring another terms of?
Yes. So
And
when
all
it
the
touches
laws.
on the terms and conditions of the employment, who is to bring it? Who is to plead and prove it?
The
law, the court, the claimant. It would be good to appeal this matter. Let us read the judgment and maybe just comfort. They are lawyers.
It's good to
It would be good. Let's just hear and see.
Not a law that was not before. The problem is that
no,
it's a law.
I flow with the judge. I think I flow with the judge. I
When
flow
you say
flow with the judge.
Right.
No, that's what I'm saying.
He has to resolve.
The argument we got the point that drew his attention.
He has to resolve
No.
When you say statutory, you're talking about a law. So he's like, let me
Let's give those three judges for. Let them sit down. So that we are correct. They will do it. It's accurate.
You see, why did he even think of this institute of management law? Is it because the terms mentioned it? Why didn't he think of any other law like civil service rules? Why didn't he think of any other law?
so
So I want to trace whether it was
that
truly
means that
before
the letter of employment is invalid. The letter of employment is invalid because it's taking terms that cannot be upheld.
Thank you.
So that's
Ground stay. Let's be thinking. Comes are coming up. It's true. Don't follow you back. Comes are coming. I should be an interesting.
Because I said this is what regulated my employment and you abandoned it.
And you went somewhere. That's why.
So that means
Even your
that
employment.
Why didn't the judge go to civil services or any other law establishing cross river?
no, that law
I'm just
establishes
the
institution.
institute. So when it's specifically for one establishing.
So if this institute employs someone,
What about labor act establishing all
Let's not forget all
regular
when
contracts?
we are drafting.
I'm looking for what gave him the link. It's not like he on his own thought of which law.
yeah,
If I'm not
I'm thinking of
forgetting,
the
about the letter of
judge
employment
changed
itself.
the law. Went outside.
The letter of employment is
Actually,
outside the provisions of the law.
Yes.
Even if the employment is irregular
yes, so it is
by the judgment of the court.
because the letter of employment says, and you say no, I'm not relying.
That's what I'm trying to say. What I want to say. Are you for sure that there's nothing in your statement that links any of your pleadings to this institute of management law? That's what I'm saying. Why did
So yeah, what was
apart from the fact that okay, this is the law that established this, there might have been other laws that connected. You understand? But what is it? Because the conditions of service, the
No,
power
and the letter was employed by the
that you raised. When I know statutory, but
The claimant was employed in
no.
the
The judge now had to say what is the nature of this person who employed this man.
What are you trying to ask?
I know
Why
that
the court will leave every other law
and go to
you go to the one that binds the civil service rules does not bind the man.
okay. So what if there was no law establishing this?
Then this is the law that you will be bound to rely on. It's like
This small
Then it's not applicable.
not applicable.
See why I'm saying so? That means people are just by all your arguments. You are saying that definitely, whether or not to place any law, what the judge look at first is to go to the law establishing the institute. So he has the right to do that.
Yes,
so how can
nobody
you
has argued that he
people, so how
cannot
can you people appeal if you
But
don't
in doing
had
that,
court?
in doing that,
He abandoned the documents that this man came to say this is the basis upon which I am here.
No, so
Okay, if he's supposed to still uphold this one, why did he bother to go to the other one?
By that argument, he has even abandoned.
No, but you
understand that you said
law,
very, very.
why would he bother to go to the law establishing the institute if this one is sufficient? If you are saying you should not abandon this other one, why is there any need for him to go to another one? You should just rely on this one. If there's a need for him to go to another one, means he can abandon this one and rely on the other one that he went to.
I think when you caught that day when this man gave judgment,
The only reason he went
nobody
to
was.
that one is because that
Yes.
one.
Yes, there was a matter like that where he gave judgment, nobody won. Nobody. He said this one did not put this one. If we are relying on the law, I would have said this thing goes that way because you tendered. It means that your employment was irregular.
So we did not even follow the law in
Because you
employing
didn't-
you.
So yes, there was a judgment he gave. Nobody won. This one lost. This one lost.
No, how did they not follow the law in employing him?
Maybe
We
he's
employed
okay
him as an
now.
adjunct staff. As
Eh,
a
but
part-time
then-
staff. And we say he's entitled to 1 month.
So we
notice.
employed him first of
Dismissing
all as a part-time staff and
Okay.
converted him
To adjunct, which is
adjunct.
No, but
So
what
that
he's
means
saying
all
is
of
that
that
you
was
employed him
wrong.
as an academic staff, irrespective of the tenure, and the law provides for academic staff. So it was not irregular.
We have been shouting.
We will do our work.
If it was another extraneous material that he bought, I'll say we have a claim. But this one is law. The law is at the press of
Only
the
thing-
judge. There's no how. If he could even have bought constitution, if he felt like
You
because it's law, right? That's how I'm thinking. Because it's law, he can bring any law whatsoever.
This
No,
man
I
is
don't
saying,
I think so.
this man is saying he's entitled to 1 month notice. That is what is in the handbook. But that they say months that it is not determinable. That's what he said. That it's not even 1 month. It's not determinable. He's pinning his leg on his letter of employment. Judge comes and says, Is this 1 month? There, it's not 1 month.
It's not good enough for you. Let me give you something better package. Let me give you a better package.
When we see the
I'm just thinking of this. I'm just thinking of this. Punishing the boy.
The boy wants to work.
He wants to work.
And this girl has to follow him.
Yes.
So they will go.
Maybe when I was carrying them to go and buy me that place. You remember?
I'm just thinking. So Isaac, what we are learning here, or what we learned today, is that the judge has the right to make recourse to any law whatsoever, whether or not to bring it. No, see, wait.
How you not understanding that ITM papers?
I know. And see what I'm saying is, if ITM did not have the law, if
I
ITM
cannot go to Judicial law, University of Calabar.
Wait,
I cannot go there.
can it go to the constitution if it applies? Do you understand what I mean? Can it, I think, does he have the right to use any law to resolve the matter?
Private law, they can even resolve it.
Because if you say, if you say it must be a specific law, it must, I don't know how in my head, but
I know what
by the provisions of the constitution establishing the judge will resolve.
so as in, like, even if it's not pleaded before him, he can say, oh, this matter, oh, the constitution provides for a certain right here, so I'll bring it. You understand? I'll bring it and to resolve it. And forget that.
I agree with him when
I understand that part. And you
but I don't agree.
you don't have to
Why
plead
have
more than you need to resolve.
No.
if you are partnering the document,
That's
already
what
have-
It's applicable. Whether you sustain it or not, that is.
But there's no
But you know what I
You know why
if the judge like to bring any law
because the
to
law that
resolve
says
it.
that
Then that means you don't have because whether or not to link it, you can
You
just think of
understand?
the law.
Whatever done them,
Yeah.
yeah,
Bam.
yeah.
I don't know myself, honestly.
You see that the man will enter appearance. But you didn't hear us.
It's not Victoria. Tell her.
Yes. Oh my God. Even we had Victoria. And she had
All these laws that we do in the world, comparison being respected, will constitute an authority by himself, do it in the middle of the night.
What's
Some
the
people-
one? I read the one that
No,
That's why we always
what I mean is
ourselves
we
every
create
day.
problems
Yeah.
for tomorrow. We don't know it. It's not like we can think of every situation. But there are some things.
But
This
their
is
hand
even-
should have guided them.
this is very fundamental. In every institution, we have
You
the
have
people that are
categories
part-time.
of
We have
staff, exactly.
we have
Then
then
in our civil service,
exactly.
it's basic.
What I'm saying is the usual course of
So
business.
that
You
means
have
that-
contract
so
staff,
that means
like
that
different
the
categories
cleaner-
of staff.
The
Exactly.
cleaner in ITF
Because it's a
so that his wages
not
are
an academic staff. Okay, my
See,
dear
there are two
brother,
things
what
we
about
should
contract
be
staff
doing.
for that academic contract?
The law,
That
these
means
people will say
part-time
that it's an
part-time
academic
and
staff.
contract, or as long as you are academic. That's what I'm
This
saying.
judge will say that. Yes, that's that.
I just feel like you just should have said in the usual
Yeah,
course of
yeah.
practice, there's a difference between regular staff and all these other categories.
Maybe read the judgment, maybe read the law.
I will get it.
When you are
And it was a
free,
short judgment.
very short. Very short. Unless you summarize.
No, he left that.
That's why it was short
He
enough.
left that. You know, when he said that, not that.
No, my point is, his own
His own findings.
is short. I will rely on okay, this is the grammar that's our problem. Honestly, that's the right result. The result. The employer cannot really show when these ones were the man was employed, and the man cannot say which letter it was that employed him, and the judge said, "Look, you didn't prove your case. You didn't prove your case."
But I have something else that I can help you. Yeah.
No,
I can
so
use to help you.
in this case, if he just goes to the door and says, "Oh yes, and 3 months, blah 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 blah," I expect him to say something about the documents that were before him. So who is he not going to import things that were not there?
That's why they say.
I knew that. Just because we're all pregnant, where you know your decision, and clearly said that, and what did you say? Does not enjoy the privileges of a permanent staff. Sometimes I will tell that.
Guideline.
Challenge the absence of misconduct or inability to perform the functions of his office. The council shall give notice in writing of the reason or reasons to the person in question and afford him an opportunity of making the person on the council. And if the council is satisfied that the person in question should be removed as aforesaid, the council may so remove him by an instrument in writing signed on the directions of the council. The rector may, in the case of misconduct by a member of the staff, which in the opinion of the rector is prejudicial to the interest of the institute, suspend such member, and any such suspension shall forthwith be reported to the council.
removal and suspension, but misconduct or inability to perform.
For good
Did
cause,
they state
any
that?
member of staff may be suspended from office or his appointment may be terminated by the council. And for the purpose of this subsection, good cause means any physical or mental incapacity which the council, after obtaining medical advice, considers to be such as to render the person concerned unfit for the discharge of the functions of his office. Any physical or mental incapacity which the council, after obtaining medical advice, considers to be such as to render the person concerned scandalous or other.
What they mean specify.
In the termination letter, what was the reason they specified?
Scandalous or
No.
other
Okay, that is no longer profitable.
disgraceful nature which
So
the council
redundancy.
Don't have anything to
considers to be
Redundancy, not
such as to
even
render
misconduct.
the person concerned.
No, you can't do that with the
Sorry,
reason
I
why
think
we know it.
someone would have, he said was his thing, they didn't set up a disciplinary, blah, blah, blah.
And he says because he was not a feminine
procedure
staff.
for
And he said,
misconduct.
look, nobody accused you of anything, and no said we accused you. So which one is disciplinary from
From
it?
it.
Okay, so we can't come by way of this.
So redundancy, is there any provision for removal of?
It was not redundant.
No.
They say they don't have to give him. I don't have work to give him.
That's why I'm calling redundant.
Yes, that's what
That's
I call it.
redundancy.
Yes.
Okay, when you don't have any.
Your services are not for, we don't need, as in,
No.
no longer fitting.
Did you hear there was something I raised? We found we found statement of defense. We found
You did not file reply.
he found.
Okay, I thought you said in your.
So he found a reply. Then I amended my statement of defense.
Amendment date back
Eh,
process you amended.
So I said something about that there is no.
This was the original process.
See, he did not reply to, he did not amend, he did not reply to your amended.
Yes, but it's just saying that it's deemed. That reply is deemed. The reply to
That's
The earlier
Are you
one fine.
serious?
that was what he said.
That's how it should be. Because if you are amending,
Then
it
you can be
means,
risky.
no,
It
because
can be
if you
risky
are,
for you that
if, no, but if you are amending, it means you had new facts. So are you saying the other lawyer should let
And
go?
I am.
if you decide.
No, it is with the court.
Okay, I understand what the judge is saying. There's still a reply.
Yeah,
That is formal reply is your reply.
Yeah.
Okay. But whether or not
But if
the
there
reply
are
is
new issues in
sufficient.
that
is
amendment,
I did not,
yes,
you did not reply.
is it not deemed admitted?
Before a lawyer decide not to reply,
We are saying that
once
there's
you
no
attach,
issue.
It's not harmful.
Then in the event that you give back, it's taken that is reply to.
Yes, that is it. And whether it's sufficient or not is in business.
Or is it different?
I just invited the court to vote that you don't file any reply.
Unless you go and pick that old, that so-called reply versus your amendment and specifically point at the areas that you do not join issues. You understand?
That's what she meant. That's what she meant. Okay. That's what she meant, but she couched it wrong.
If they reply that your so-called reply that they say is the reply. And me, in my
I
amendment,
understand
I
what you
introduced
mean.
new things.
That is what
that
the
one
form
has
is.
not answered.
That's
Now
what
the
the
thing that you have
she
answered
couched
what
it
you
wrong.
did not answer.
She should have said that social issues were raised, new issues were raised in, and there was no reply to that. Those and therefore he has deemed those ones that.
Why should I point it out specifically?
No, but that's what you actually meant when you were telling the court that there's no reply. You were telling the court that the court should say, as in, to think that the last
we know that
the
that
last
reply
issue on
suffices. That there's no automatic right that you must reply once someone has amended, since the old one suffices. Then if you have any problem with it, it should be as to those new issues that you have.
both of you are saying the same thing. Lipon meant that I have filed statement of defense and he did not say reply anything. As in, she's trying to say that the things that I have raised should stand, at least if there are new issues, the things that I have raised should be the final issues, as in final facts on that issue. Yes, he has not joined issues on that. But I understand what the court is saying. You cannot say that there's no reply at all. There's a reply. The issue is now sufficiency.
But if you now want, if you really want the court to see that this is a new
Like,
issue, you have to go specific.
Yes.
Okay, what you're saying is I wasn't specific about what.
Yes, you wouldn't have said that there's no reply.
I would
I
have-
would have said that so fact. Like in this, I raised this. In this, I raised this.
Mm,
And
and
since there was no new reply, and therefore this is.
You understand?
Okay,
Most times you don't even need to say that the judge himself should know, right? Because if a lawyer abandons his right to reply to your amendment, it means he say yes. So the judge should
you
know.
send that document. I would like to read it myself.
Not like this.
I know those ones can still be grounds of appeal.
It's better.
Yes, now.
That
It will be a copy of the
If we look at
document.
those, if we look at the issues that you know, if we look at our amendment and what we introduced, and we look at his reply, and then whether from the evidence or from the reply,
Yes.
issues
those
were
ones
not joined on it.
yes.
Yes.
So they were things that
Yes.
and therefore how did the judge? Yes, you
I amend
understand.
my
Can
process.
become a-
You don't file
Especially if it's
any
not like-
confidential, you don't file a reply to that.
Yes.
Eh?
Whatever thing that they have raised there.
The new thing
that you have
it's not
that you have raised
not captured
by your former reply
Okay,
is
so
admitted.
my issue now is when to this hearing.
Mm.
You understand? We went to this hearing where those issues came up. And then I come to do my
Address.
Why should I go back again to say he didn't reply to when those issues were trashed during the hearing?
If they were
And then there's no
I just decided
And then it's not damaging now. If they were crashed during the end.
because what were those issues? The fact that we raised a check, blah blah blah. And the
Okay,
man
those are
said,
the things.
I think nobody said it on me. You know, the guy who took the check to give me was cross-examined.
Then it's failure to know.
Yes.
That's why it's not reply.
This is just right.
Yeah.
These entrepreneurs can deceive us. They say as supreme lawyers. In your mind now, you'll be a lawyer of the Supreme Court more than every other person whose wig does not have that title. Supreme
Lawyer endurance.
Supreme lawyer. I don't understand.
Lawyer endurance. I'm very interested.
If there's another one that they say appeal lawyer, you will not be feeling, oh my God, it means Licom is a better lawyer because she's supreme and I am appeal.
What's the date of today now? Waiting.
28. So Isaac, my whole question is not me. I've asked for anything we have done better. Yes, because I realized that if we are relying on the law would have been, of course, against us.
Right.
You know, the legislators would have specified. It's not anybody's
I
fault.
see that you should have gone to the House of Assembly.
Quickly do something. Maybe our best bet would have been to look for case law to show that normally, even if you don't specify that adjunct is not like other people, you mean that there should be a difference in the way they are both treated. And I doubt if there's any such case law. Is there any case law like
We
that?
went to the dictionary definition of case law
Okay.
where adjunct. We went to the meaning of adjunct under the guidelines to distinguish.
Wow, we see.
We did that.
Oh, there's even adjunct, the meaning of adjunct in the guidelines.
No. There's not the meaning of adjunct is not there.
Okay.
But the fact that it's meant to be distinguished from regular academic pathway, you know, it is implied in the guidelines.
Yes.
And then we now brought out English. I don't even remember now. I don't even remember it. Just okay.
It is already thinking of appeal. God, give me grace in this litigation that I want to come to. Me, I would have been here beating up myself, but she's thinking of what they're going to appeal.
But that's one judgment is against you. That's what you'll be thinking
I'm not
about.
pushing on myself. I'm looking for what I can learn from.
You know that money is even
It's
involved.
all the time that you'll be down. Sometimes you
See, if you're not
on your
thinking of
face
appeal,
now.
you're thinking of how they are going to pay him. That the is coming for the money now. Nobody will go and pay him. He's an irresponsible government. Who will give him that money? He will now start fighting for the money. And for you not to give him the money, since you know government will not pay, it's your grounds of appeal. So use appeal and block it, whether the case is good.
That's
what we do here.
Before anything, before return we will brief CL.
Yes.
Is this not even around? Agent, that's why Kimeji sent it to me. No, he wasn't around when I came. And Agent has gone out. I heard when you heard his voice. In fact, he was preparing to go out when you sent it.
When I heard it coming,
No, but this is a good reason now.
when I saw that you're coming to speak, I said, what?
No, I
We
didn't
don't start
agree.
laughing.
You Eddie will even be happy to hear that I joined anything serious in my life. Trust me. Trust me. Yes. No. It's virtual now. What advice you guys have? We didn't all learn. We didn't all learn. Okay. That was what I was even planning to use as an excuse for me. But God help me not to lie.
That you wanted to join better.
No, I wanted to tell him that I've been around since, but I've been with people listening. And I just came, but God took away the opportunity. Maybe I came. God said you are just coming, so there was no need to lie.
Who has this phone? Are you going and leaving it? Are you ready to go home?
No.
From
This power bank.
from the law here, the power of the council, and they do not provide for council making any regulations. The law do not provide any.
Okay.
The only regulation the council is to pass is council to pass regulations relating to proceedings.
So this handbook is illegal.
Not finding anything.
So
I feel that the handbook was in existence pending. Every institution has handbook. Even University of Calabar has handbook.
But if you look at the handbook, you look at the University of Calabar law.
How many pages?
The act is just. I can send it to you.
I
Please send to me too.
That's fast. Sorry.
Somebody's one you know.
Is it me? They are always complaining about me. See, they call them.
Sorry.
Is it me?
Woman. If I know the people, I
I'm not called auntie, and before she called herself.
I hope there was no emergency.
But what happened? I think you bounce back.
No,
You spend all the money.
I'm always doing that.
I went in first relationship with her mom. This is what my mother was planning for me. I'm telling you, I'm not exaggerating. You didn't know now.
She didn't know the kind of woman. She said she didn't.
Let me not say now. I'm calling for people.
I don't say.
But this was like what you know what I mean now, right?
The motives are different.
They are the same now. Because her husband has just died. He's busy up. Hey, sis. Hey, sis.
Hey, okay, good education.
Why?
My own reason is always there.
How? Are you the one that dismissed him? Without looking at the result? So what are we talking about? Like you still find a way to
No. I feel that I don't feel
That's any so we're improving every day. Now we are learning. See, it's not more than us. It's experience. It don't matter. We don't know law. That is the truth. Like once I import every day and be hearing other people's matter. If you don't do matter by yourself, you will not know law. If you don't do that research, argue it, the rule against your rule for you. It will not enter your court. You don't know law. Yeah, how many things have I learned today? Okay. I learned okay, this thing about reply. I learned it today. The reply that this guy did not file after an amendment. Now it dates back to the original. Just learned that one. Okay, then what else then? I remember, but I know there's something else that's come to mind. Okay, there's something else that is very important. Any matter that they give you, think about the law that guides people.
Yeah.
So it will not.
That's why I said.
Yes,
That's why I
it will
said.
not be surprised.
That's why I'm saying I did not reason like.
It will remove the surprise element.
You know, if I had gone to sleep, I would have been able to tell myself, "Oh, this one doesn't fit for me." And let me just
at least it will remove the surprise element, or it will change your attitude.
I didn't affect my mind to the fact that
that's a major error that all of us.
And you know where I was coming from? I was coming from that judgment that
okay.
Came in connection with that foreigner matter.
Okay.
You know, he said his employment and just he was employed by the first class state government. and the judge was able to distinguish it. Say, yes, not just a government employee, but you can't be said to be a civil servant before. Okay, say it's a civil servant that is money, how did he argue it? But they say, look, under the civil service, we have headers.
Okay.
You cannot put where you fall under. No civil servant was earning what you were earning. So you cannot be said, that is where she came from. So I think that was what pushed my mind.
Okay.
Just because on that line.
Because it's our own aspect. But the law that the court relied on does not have.
Because he got his letter of employment from Civil Service Commission. And he came into a competitive process. It was advertised and he responded and he sat for the exam, went for the interview, and then Civil Service Commission, okay, head of service, what do you call secretary, gave him letter. Civil Service Commission gave him letter. So he's like, I'm a civil servant. And the judge had to distinguish, so I was now coming from that angle. I think, but like, let's look at what you do every day. Let's compare you with the regular civil servant. Kind of say so that's, so my own is to learn to expand by thinking, not to be narrowed
You
down.
get better as you're doing more matters. That is how you get better. There's no other way. Isaac, is there any other way? Don't know any other way.
Yeah, I will learn. But that idea that you can make special that I will not learn from that.
Then another thing is to consult people that are good in that area. Like this industrial code matter they're doing, there's no how I will finish without showing you. There's no way on earth. It's not possible.
So I will like to also.
I don't even know what I will. It's not looking exactly like it.
What did you just do? That was supposed to be.
Yes, I'm trying
Serious.
that one.
So when they give them and you do this,
I see their things. I just remember something happened. She will not come out there when it's time to write. Undefended list.
Write it down.
Undefended list.
Summary judgment.
Undefended list. Interest. Interest.
Not undefended list. Summary judgment.
Summary judgment. Interest. No. So that's the end.
Undefended
If you don't do the same, that's it. How did I now think? Okay, you have been guiding me since, but it only made sense when I wrote that piece. Because I now went and sat down and read every authority in my hand and find on it.
Okay, sorry. So what next on this matter now? Written for that form.
Yes, the right return report. You can do that. Nothing is wrong.
No, you write. Do a memo to
Okay.
coming of judgment, the amount, and then you can now suggest you can suggest a gift.
Okay. You also ask for money for it. You compile and transmit record. Why are you laughing? That's small money. You compile and transmit records. That's the challenge with that. Can't even use their money to do this. They don't want to bring them back. It's not my head. Very simple. Give me charge of them.
Don't have to.
I want to go now. I mean, it's.
You don't have my case. I don't know. See, when I go up there, when you say that I'm charging yours, when I see that, I feel that I need to come and pass and see you.
How far with you and Aurora? Person when they do project, no, they get sponsor money for small things. If you're not in the project world, you'll never
When
understand.
it's ready, that there's no light or the child is not around. Am I so confused?
Yes. Keep on.
I'll come back to this. Even though it's like this, I go to this class.
Can leave them here.
That's in the law.
Okay, thank you. Are we going to see it?
Okay, this year. Let's go now. We now say 2 women that have lost the case have come within. These are the women that work hard.
Some beliefs.
They're easily throwing it away. Just make this case no difference. No difference. This case no difference. So I'm not listening. I am not them.
That's cool, yeah. All right.
I want something that employment to. Something must be clear and undisputed. Then interest, the judgment interest.
You're writing for this one.
Yes, the judgment interest. I don't want to forget. It's not big. See now, this thing that I know now is from another matter that I just finished. You understand? So that's how you become an expert. This will be my reply to this. This will be in my argument, in my reply, in my counter affidavit. Okay. I want to carry this book. How are your sisters? Where would they come?
My sister has problem. One is what? The other one they come on. Eh? Her problem is that the road is bad and she can't come by air because there's no light. There's no light.
It's not far.
She comes from Abuja. She goes to see my sister in Abuja. She now fight.
Which matter? That's good. That's good.
And you look good. I like your red red.
I look good.
Yes.
Oh,
Red shoes.
Okay, it's because of this serious thing.
because
Sir, you look good, sir.
This man has hey. So because of that virtual hearing, this people format and not and they record today. I think the emotional expertise.
Yes.
The emotional expertise asking for another to, I think, prevent them. Like over the weekend, I went and on the class A1. Yes.
to prevent
Prevent them from the civil servant, that's the official purpose. Why are you chasing him out of the place?
Good afternoon, sir.
Yeah.
Good afternoon, sir. Happy weekend. Yes, thank you.
Seems like what I know. No, they don't. The fair boy. Yeah. I like that. I wanted to put in the class.
I think
So that people can have that. It's the one that you can always see. No, don't worry. We can do it.
So is that a Bluetooth speaker?
Yeah, let's go. We can do the start. Yeah. Later we can do the formal.
it looks like this. Isn't that it?
It looks beautiful.
It looks like it.
So what is that view on that?
Just from employee. No, the court even asked him.
Yeah, to address him on jurisdiction.
I think so too. Is it because anything because the employee go and look at that to what see? But that operation, you address I gave that. I told you why I did not want because you live around it.
That's the land matter.
Yes, right. It's not
Employee, strictly.
Let him address because I'd like to hear the cost view. If I would do that,
He has 2 weeks.
I would have also okay. It came up today, expert.
Yes.
Okay. Yeah. So that's why I will have to let you know. I will speak with her. She has many brothers. willing to support in terms of ideas easily, because if they refuse or maybe they say they put them on notice.
They said that they should serve a hearing.
This one, okay, they have not, they have fixed the date.
Was that the 25th?
What does he want? As a matter of fact, experts, they're not supposed to go that through the virtual hearing session. We're going to know about it. Okay.
So is this ITM? Why are you laughing? Is this ITM ITM matter? This man is challenging. Yes. Challenging the termination of his employment. So.
Who used to do this? Okay. Yeah. Come inside. They are looking for who? Afion. Okay, I send her. You are who? Your mom.
Lamoni.
You say Lamoni or me?
Who is your mom? I don't know. There are food, but this one is fine. The other one. But I will not release to you until it's not here. And I don't. In fact, tell your mother, if that is the food, the food is the food.
Turn up your country.
Okay, so that he relied on his letter of employment, his conversion letter, and the termination letter that was sent. The reason given for the termination was that his services were no longer profitable to the institute. But he was arguing that no, the school has not been accredited, that there was still opportunity for him, blah, blah, blah. So he tendered, along with his documents, the handbook. So our argument, the institute's handbook. So that is where we are now. So we now, that's the issue in this case now. So we argued that his employment was not of a statutory nature, didn't have statutory flavor. We made a distinction and we cross-examined him based on the documents he tendered. Okay. You have a letter employing you as part-time. He said yes. And you were later converted to adjunct. He said yes. Were you ever converted to a permanent staff? He said no. And when you read that jointly with the provisions of the guide, it shows that there are permanent staff and that part-time staff will not enjoy the benefits of full-time. And this was also stated in his letter of employment, that remember that you are not a full-time academic staff. So, that was our own argument. I know that where we defaulted was where we didn't give him the salary in lieu of notice. Their own argument was that they raised the check, they gave him, he refused to collect. His argument was that his monies are paid via bank transfer. So although we raised the issue that we have the discretion, but what the judge did was neither to look at his contract letters of employment nor the handbook, but to look at the law setting up the institute. Nobody made reference to it. So he made reference to it and said, because the ITM is a creation of statute, that staff there are said academic. They don't make a reference to staff for how academic staff should be disciplined, and there was no distinction between categories of staff. So therefore, his employment was statutory. That he was an academic. That being academic, his employment was statutory and was entitled, going by the law, to 3 months notice, not the 1 month notice on his contention. That was even in contention, and that is clearly stated in handbook. So
Both in the handbook and in his
Employment.
termination
in his
letter.
termination letter, yes, and even in the issue we raised in his letter of employment, there was a typo. He said that his employment is academic in nature and can be terminated by either party giving months notice. There was no apostrophe, and there was nothing to qualify. So the claimant counsel was saying, look, it's more than 1 month, but an argument is, if it is not 1 month, can you tell us how many months it is? So we solved it by defining it from the handbook, which said it is 1 month. Now the judge has abandoned the handbook, abandoned his document, and says it's entitled to three months in the law. So if we go by the provisions of the law, it means the contract that he entered into with the institute itself, it is a void.
So that contract distinguishes categories of staff.
And it runs contrary to what
is in the law.
In the law. So
only one.
Yes. So the judge did not abandon the document. So he actually did the case for you.
So what were the reliefs?
He granted the reliefs. Okay, that he's entitled to his salary for the period he was suspended, where he didn't work. Cost of litigation, 200,000. He's still the employee of the first defendant. What are you looking for? So that the later terminating his employment is void.
5 million damages, 610,000 naira, paying his unpaid salaries for 10 months. Everything, then 200 cost of action. We were thinking, what would we have done? I didn't figure out what we would have done. Because if we had people seeing the law, it would have worked against us. That means his termination letter was problematic.
From the fact that were given that helped you to fashion out their defense, it was terminated because the institution felt that it's continued being in employment was not beneficial.
Was no longer profitable. They didn't have enough credit hours for him. That was it. But okay, but so the new issue is that there were interpersonal issues. So there were things he didn't. If he wanted to be converted to a permanent staff, and they felt we don't have costs for you, and he's like, no, there are opportunities. This school is not accredited and ought to be accredited. When the management didn't listen to him, he went about writing, indicting letters against the school. So it was on that basis they didn't want him. Yes, they didn't want him anymore, but they didn't come from that angle there. That's actually the main issue. He brought that issue in, but because the letter he tendered as having delivered to us was never acknowledged, the school said they were not aware, and that was not the reason why.
But the problem still goes back to the school. Even if they now said they would have complied with their law. This is their ITM law, they are the ones that are aware of it. They are the ones that have staff handling.
The ITM law requires 3 months.
Requires 3 months notice.
But his
salary in lieu of those 3 months.
Yes, but his letter of employment said 1 month. The staff handbook says, the staff handbook said 1 month.
And the court said between the law and the handbook that the law.
His own argument was that he was disciplined and that he was never asked to defend himself. But we said we were not no misconduct was ever alleged against him. That's why they wanted to come.
Yeah, not just that we can be hired and fired. It's just a month.
So we had defined his employment as that at the pleasure of his employer. So, but what the court has done is to go to the handbook and define what and say there are no categories of staff in the handbook, that there's only academic staff. In the law. But in the handbook, it categorizes them.
So you abandoned the handbook?
Yes, and abandon the
letter.
Yes.
The handbook, in the letter of appointing of employment or appointment, was that considered also?
He did not, the judge abandoned this document for him and relied solely on the law.
What the judge did was to determine whether or not the claimant enjoyed statutory.
And that if
and by relying, and the court said that to determine whether or not your appointment enjoys statutory, whether or not your appointment enjoys statutory is determined by your mode of discipline. Whether there's a law that stipulates how you'll be employed and how it's terminated. He referred to authorities. And then he came to the handbook and said that the handbook stipulates, the law of the institute that governs the employment of the claimant stipulates how he will be employed and how that appointment will be terminated. By that fact alone, that is an appointment enjoys statutory. So it was now whether we dismiss it in line with the requirements of the law. And we did not. According to that, of 3 months notice, salary in your 3 months.
But there was a special relationship.
Very simple judgment.
There's a special relationship between him and his employer, which is evidenced in his letter of employment, but the judge abandoned it. The letter specifically said, take note that you are not a permanent staff and will not be entitled to the benefits of a full-time staff. That the letter was clear.
So what are you saying?
And we reproduced that clause. Okay.
So very easy to extract. It's not the appeal from what you have mentioned. You ask me to the little document. I can have a view, but are we even ready to do it? Is the ministry really?
Compile and translate records. Do notice and transfer.
Because as I've seen on the that we have grounds. Then some of this is not for anything, let it be tested. And then now expanded. Because I can remember authorities abound where the data of employment, there's no way you can complete it.
That's what he did, he completely ignored it.
Because at the end of it, that determines arising from, yes, we have that institute. But we are zero down, and it was very specific. Expertly stated in the data of employment that define our relationship. And this is who you are and what and all of that.
So should I read it out? I want to read that. However, your appointment is academic. Okay. Okay, the title is Conversion Letter of Employment Status from Part-Time to Adjunct. Management in its meeting of Monday, 3rd September 2018, approved your conversion from part-time to adjunct academic staff status. Hence, your new rank of technologist 1 on takes effect from 1st July 2018. Please note that as adjunct staff, apart from your specified emoluments stated above, you will not You will not be entitled to other accrued benefits due to full-time staff. You will be expected to be on duty for no less than 20 hours per week. You will be expected to participate as may be demanded in every educational/student-related activities within the institute community. However, your appointment is academic in nature, and it may be terminated by either party giving month's notice or by payment of the cash equivalent. That was clear. Yes.
The appointment is academic.
And it may be terminated by either party giving
month's notice or by payment of the cash.
The institute may place this sanction on you if you fail to meet up with the job demands or by violation of any of it. So this was the last, this was the letter before the termination. So he was never, it clearly states that he was never a full-time staff.
And the statute, the law.
No, not the law now, the handbook, which he tendered, because he said his employment is regulated by his letter of employment and the handbook. So we were reading both of them together to say, look, even the handbook doesn't work in his favor. Yes.
The handbook says 1 month notice.
Yes. And it shows that he's not a full-time staff and that only full-time staff enjoy certain benefits. The handbook is clear on that. And so that was what we were relying on. So the judge abandoned the handbook, relied on the law. So my question now is, can a part-time staff of the institute now say, okay, the word part-time doesn't appear in the law. So therefore, I am a full-time staff.
And entitled to salaries of full-time staff.
So that's what it means, because the judge is saying what we have there is academic staff. There are no categorizations. So can a cleaner just wake up and say?
So if going by the law that the court relied on, his termination was irregular, that means his appointment too was irregular, because his appointment did not also follow the law.
However, let me say, and get something out of it. Just to know, this is a final judgment. The NICN has special I've not practiced enforcement for a while, even the judge said, except there are small conditions when you are appealing, whether that has been taken out, you cannot appeal without leave. But save in the expression of fundamental rights. But I think that has been look at the rules by the Commission on the Land and the Parliament rules at heart. And then the LSC rules itself, regulating appeal without need. Now, having said that, we can create ground. I'm looking at the complete decision of I can frame it better. So the handbook, the document, the letter of employment, all of that. Okay, I'm corrected. His judgment, particulars, sometimes you can even look at law reports to see what is expected when he has to do Later on, employment and all that, I recall it defines the relationship and all that.
So this another issue we're able to think about. By relying on this document, this handbook, when they are actually at the law that regulates terms and conditions, can it be argued, can it be said that the claimant has pleaded and proved his terms and conditions, which is a mandatory requirement here for any employment or any claim for wrongful dismissal? By relying on this wrong law, yes, this thing that the court refused to look at.
And then, okay, arguing on the other hand,
yes. Can we
Yeah,
argue
very
that he has not proved his own case by bringing this document instead of the law?
Because he said it regulates, this is what regulated his relationship.
Yes.
That's what he specifically said.
that's what the flavor says.
Yeah. And pleaded, yes.
Then,
And this is what we use to try and resolve that.
And resolve by
once
showing
and
that
one
look.
book, yes.
but now, that their question, they are saying that even if, okay, let's take for granted, they rely on this, and this was perhaps the little to be considered. Even on this,
Yes.
they are not good.
Yes.
That, I think that understand of because terms. We need to know what is the status of this. This is not the first. When
So the court cited authority. There is a law that will prevail over this.
Of course.
so for them that's the special. So all this
Yes.
that will let go of some. And there was a time I was doing living there, like I see
Susanna, he lives there now.
and
That's our house. And I feel.
the other thing is that takes you to really more of the but then we were having more cases that no you need it.
The employer makes it difficult for you to win it by not following their own law. Yes.
It's very like look out of you will not just the steps to discipline is
They don't follow it. So it's the employer that makes it difficult.
they don't even give when some query was later arranged.
You don't remove somebody's name from the field.
So there was no at no time the person signed up for the sometimes in local government is difficult. They don't go to work. They just stay somewhere.
There's no work for them to do.
And then suddenly they don't see them for many years of months. And then, like I asked the man, he said, what do you mean you want to do for it when you
You invite them now to come to work
So
for a part
way
or screening or something, they will come.
and the one your name was taken away on the stop, that's when they came out. They will definitely come out.
Find it.
A car was making that sound. So I think we can get out from something from this. But like I said, you put up that this morning I'm sure I'm going to go and try and do it for me. The one that trying to then we contact things up to well. I was doing all this and then just all that required to know if they delay to the registry, because whether it is intentional or
They are saying inside of the record already.
now
The number of copies.
If they will be expected to be. Maybe bring back the man, the act for reinstatement, the act for reinstatement.
Yes, yes.
The act for reinstatement.
But you got there that the claimant is
Still in the process. It's not a matter of reinstatement. He's still
was never
so.
terminated.
We are owing him.
So was not a question of it, never being removed. It's just that we don't want to again. We are not useful. And the man went to okay. And then in doing that, we did not give him the adequate length of notice. Is it confirmed that we did not?
Yes.
So we have a problem there.
So that was yes, even the 1 month notice that we we were originally relying on, they still did not comply.
You know, like in my place, I was saying my dad, what it means is, you see this hawk, or kite, or hawk that goes to get
Okay.
and how they call
The
it?
chicks.
The chicks. Carry one. What it means is that you have to also be careful as the gamer that use the hawk, direct interpretation of that. You know that this guy is over around and the problem to take you. You have to kind of do this. And to speak to this one. In the first place, we want to implement this plan, even on our own terms. The 1 month or 1 day.
Even the salary in lieu of notice, you know between
No,
us that
we
they
did
did
not
not give
give.
it.
The only argument they put up, which was that when it comes to salary in lieu of notice, that they don't do transfer, they issue checks because they need that staff to be physically present and sign and collect, so that it forms part of their records. That was the defense. That was the defense that they had in that area.
But normally they do transfer.
Yes. That was his argument that he gets his. In fact, even the monies he said they were owing him, we were able to prove from the this man's case was bad against him from the way I saw it. He tendered documents to show that they were owing him, that he had not. When we amended our process and said this man says we are owing him, there's nothing before the court to show that we are owing him. He now brought his statement of account, and yes, within the month of July, there's nothing flowing from the institute to him. But in the testimony of the accountant, staff salaries for the month of July were paid in September because there was no money. And we tendered documents to show when instructions was given to First Bank. And we tendered our own statement of account from First Bank. So his own records showed that he had lied. So everything was actually moving against him.
The court judgment, I think there is a condition.
Nothing. Sir, he just abandoned this whole thing and just since we raised, one of our grounds was whether his employment enjoys statutory flavor. So the judge just picked that one.
Only that one.
Yes.
Yes.
Well, how do you determine whether it enjoyed statutory flavor? It is by looking, by statute. So there is a law, and so if there is a law, how does the law look at him? He looks at him as an academic staff because that's the only definition of staff.
That was their only issue for the government.
No, that was not the only. That he relied. I think
was there. After the judgment, you not even talk about
whoever asked me for more than an hour.
For and again.
I thought you're right. If how many issues do you raise?
Okay, sir. Fundamental issues, but the other one, the first one, whether it enjoys statutory flavor, then the other one, whether he had proved his case, and then in
Whether he has proved
his case to entitle relief. So for each relief, we argued on that. For each we argued, yes.
On in giving the judgment, what
the court did not talk about whether he has
asked the law enjoins him to give findings on the issue that you raised. That is why when you argue that he claimed salary for that September, that July, and then you show evidence of if you had evaluated evidence, he would have come to a conclusion that. But because this one is not giving a blanket directive.
He didn't address that.
Let's not read the whole judgment that he prepared.
He did not.
We read it,
that is a ground. He did not make findings on this.
On the fundamental issue.
He did not evaluate the evidence. We have to ground. And then, so, but like I've said, you can beautiful grounds of appeal. Sorry, in matter like this, NIC, do we need leave? In that order, except this right. So that means that I thought that recent authorities have done away with it.
It's not the previous version was that it's not appealable.
You don't even appeal.
Now they say there's no call that because if we say not appealable, so you can appeal. But if you are appealing, it has to be with a view of court, except it's an issue of fundamental rights.
Then you don't need leave.
Or yes, or it's the issue of if it was a criminal trial.
Okay. Then you don't need leave.
Those two aspects.
So the final one was that you cannot appeal unless it's an issue of fundamental rights.
Yes.
So as it is now, this will be final court.
That would have been final.
That would have been the final.
Right now. So
now you can appeal court with leave.
Yes. To my mind, I have identified appealable.
Now we need appealable money. Now.
So that was how the issue.
Or we should just do notice and grant of appeal and leave it. Okay, I'll be the motion for leave first.
Yes,
then
the motion for leave and then attach
the notice
and
grant.
When you do all that, they also, these people, they are, not high court that you play anyhow. Certainly, at the certain point, there is one appeal, they have this. In fact, sometimes they send you that. Okay, they also require that you pay certain money for records, yes. But this one for appeal, this is one for appeal. Orders to show seriousness.
Plus this there's an amount of money now that you pay to show that if the appeal is frivolous or that you will not abandon your
NIC.
Because it's federal. Yeah, you have to pay. They don't exempt.
Yes, in each of our fields.
The filing is we file official.
Well, we pay penalty.
And when you are when the high court, you file official. When you are within that,
okay, you pay.
My brother.
High court, court of appeal, we don't pay penalty.
One matter is no problem. One matter. Environmental right 5 days.
Does she know?
Is it budget?
She may not even
I
know.
stole my phone.
So coming back now, each day is 1,000. And so I consider it as well. Let people know. It will not, there is nothing I have dissected it. It will not cause any problem. This is a federal agency. So trying to pursue that, but at this time it will be close to 30,000 or nothing. Then the one things that I found 3 days ago. Federal High Court. Federal.
No, NIC.
Don't know the Federal High Court. It's same parliament. The one said I already programmed my mind to maybe 7, 8,000. That's why you notice this calendar. I marked it. I marked this calendar. This there are no. I mean, we filed on Wednesday. But what I read there, we were several that began to run on foot. And it fell within the that is what I was calculating at least 8,000. So when you said, oh, it's already after time. Calculated this start of the show, and then that was the last week. Another thing so anything very terrible. You can prepare this with all what you have discussed or pending when you receive this. But how do we possibly have this? Report for zero concern and because one, I do not see government willingly obeying this government. And then you just keep quiet, you don't obey, you don't take any, or you don't pretend to protest, just stay there on the now means that you once they get to that kind of say Wahala.
The state is not ready. Not ready.
A lot of things need to be.
The state is not ready.
I just pray.
They are the ones that pay. Will you forget that you have a law? You want to appoint, you want to terminate, you don't have to look at your law that you yourself. That's when the problem starts from now. Okay.
By grace, I think I will be in a position. I don't know. Next age, my age will be education age. Not the education age. I know. You may come and get another one. It's an armchair. So, like, you don't like going. So if the deliver and he's willing to give time, he says, director, let's discuss how we do the things that he need to do on. And most of the problem, almost the problem will have come from the MPs. Like now, let there be some kind of training for them. And let them understand the consequences for not doing things right. If you are in local government where they require, let there be some things can have a seminar on these civil service rules, disciplinary action, steps to be taken. I have those kind of people that kind of name of different communities. I can tell you from the period I am here, I know the kind of cases that goes to NICM. When it has to do with NICM, it comes in various ways. Salary has been removed. That's name, salary or your name taken away from the payroll. It's inflation. I just the was doing it, but it's common now. That is not the way this is being after the exactly. I've read one judgment by this man, but the man was right. He analyzed it very well. He has looked through, it's not one of the ways to distribute. So we have this. And also, my personal experience when I was in local, for instance, local government, people don't go to war, they don't. If we must tell ourselves, this is civil litigation. Normally, you are working in the law office. This is not how to work in the law office. My brother, I didn't know, but I know I heard that the Senate, the law office is where people come. You don't sleep very well. Not that you won't sleep, but you are conscious of their responsibility. Sometimes I tell you, I pray the prayer, very simple prayer, but very important. I pray. I ask for wisdom, I ask for understanding, I ask for peace. It is not everything that they talk. Sometimes I hear God talk in your heart. You humble yourself to ask God. But I observe a lot of lands. You are not under nothing but I don't tense. No, they're not. Anyhow, there will be this. Anyhow, when the government when it is they will bring to the correct. Anyhow. And for the few persons that are speaking, I say, anyhow, do your best to defend and let's see how it goes. Start from the wall and to your house. Now, if wars come to us, many of the cases are not. So, the incoming, I have been understanding of 75. Please, let us be good and let's train. These are not things we can do. In the right time.
The Ministry of Lands, they need to be one
seriously. We identify
Ministry of Lands always in error, and they know
that this infrastructure renewal going to get people
without.
So you always struggle now to come out with the winning regulation, the airlines, the power some benefit, and all that. A lot of lawlessness. What will happen? Set the Minister of Justice. Now, I observe that we don't have enough manpower to send lawyers and secondment applications. I don't think we have enough. So that if you are enough in the FDA, because certain actions are taken, there's an in-house, you consult that person.
So it doesn't work like that. Me and my BPP, do I know everything that happens? Like this matter that they complained about, for instance, did I know that there was even something was advertised?
But that is not normal.
The governor will just call, they will run.
I just saw, I think it's recently, I saw online, I noticed that the advert was made by the law firm of Aloko and Oyebode. That matter that came, it was Aloko and Oyebode who advertised. I'm not aware.
On behalf of
am I not in the Yes. I'm not aware.
Not giving these facts. We want to discipline these facts. One aspect is NICM, people being terminated arbitrarily and things. Hence, hopefully, the due process of discipline. That is one angle. The angle of stopping salary, moving them up the okay, and then not paying salary at all, like this local what kind of some of them are 3 years initial disease and one kobo. How much they can do that?
Then we're expected to go and defend how when they now go to court.
So I'm telling you, I've analyzed that is that. You cannot think like this. In the incoming regime, how do we get avoid some of these things so that we can concentrate on the serious. These are distractions. If things are done right,
You can now focus on the real
there are
job.
some areas that not everything you manpower wasted in NICF for if you employ somebody, you don't want to employ him. Don't take him. You employ him and then you don't pay him like those district courts.
It's true. Did I tell you to employ them?
Eventually, the day of reckoning will come. You can live part of
I'm part of them.
yeah, part of them.
Yes.
Therefore, so those ones, you get to stop this kind of situation. The left manage the one already, knowing very well. From next month, June, July, there is going for allowance. All this one we have been doing. Most of the especially those contacts we go to their and other on mainly is NICM, where it does not pay people, where you go to do from job, and where you go to people's name. I pray this new man is not that's what I'm saying. The aging cities as a business pattern. And this pattern of wear people out because the things are not necessary.
Like this file you gave me, is that necessary?
I do.
That medical doctor file. Pay him is 250,000. Is he not a medical doctor? At least pay him his complete salary. Before we go and be checking whether it is summary judgment. They should not do this. They should not. But it's not entitled to his salary. Do you understand?
You don't have all the money to do now. You have been rewriting and writing. Okay, you instead of all,
why do we contracting if
you make 2 million first? Then there will go. I mean, the man don't hold something.
Yes.
But when you do what you like,
I think they're trained us to come and tips. Yeah, you don't even know.
What I'm saying, it makes sense.
It makes sense.
It says this position. So take this position to the content. Let's sit down. And what actually are the cost is that
the 40 ministries should bear the liability.
It's not still government that will. It's still government now.
Like this man now, this Okamite, should go there and collect the money from there.
Consequences of people is big.
Yeah, the nobody did not fire him well. Let them pay.
When I came here, I was
they'll wake up.
So scared of seeing a case that have money. Because the one that we already organized so much money right to be done. So whenever anything comes, 100 million, I will see sometimes write the thing and just you go and this is make sure you I don't want to wait. And it was living someone. That means someone 100 million. So I need that. Let's talk after you cannot say after you will see. You can't ask somebody ask for 100 million without this week. You will see this week.
Right, because of their mindset.
And then many you see. Many things were added. There will be this week, anyhow you want to see. So that it will give you a little time to pass and then think. Okay. So when I took over what they when it was 3 a.m., I used to see something around 3 a.m. One of the days I was there, I saw many areas of this, many. And then we pay a visit to the commissioner. Some of the memos were generated by a certain director who has interest in the contractor. And then he did all those things. And he got to the hand of who used things, and then there was some conflicts and all of that. Because even the that he noticed this thing, And he told him, maybe he brought the man to repair crane. And repairing that crane, there was an agreement. After that, he will put the amount monthly. And after a while, we found out more for, but that was not captured in the deal. We also found out that some doctor. I don't think as of the last I asked because you get to see and all we were saying that they are not doing that. Either is not funny, but if you do not do anything, somehow you are either dragging or something independently, they're not either that they are not ready, government is given, and then you now be struggling. That one of the matters we do on our kids, if they have looked well, these are borrow this and rest of them. That about the sort.
Okay.
So then I saw another one. 50 million, 55 something. So most government officials, they can do it directly or indirectly. Now we have a government of 78 million. But I think that was yes. 80 million. That matter was not.
But who is the lawyer? Who is the lawyer that did that matter? If everybody looking for the lawyer, why are they looking for the lawyer? It says I'm not dependent.
No, it was not dependent. Let me tell you a story.
Like undependent list. Nobody has that appearance.
No. Yeah, prime statement. The written statement on food by a staff company from the Calabar. When it was revealed on the fence, come and testify.
Like that, man.
Come and
This also even went there and said.
That's when he finally
Entirely witness.
No, these teachers. Each time that matter comes up,
You will not say
you will not be in Calabar.
those are the kind of things I will address.
Okay.
It has taken me time, but I believe by this weekend.
So the witness refused.
No. I'll tell you something. I'll take my time. I'm looking for it because I took it home to capture certain video. So yeah, I don't know, but this one is and good global investment, what I'm about that. What I see is 78. Yes, 78 million 425,000.
Okay,
Paper. I don't have whether this guy will continue for okay, let me check. This is the one that is here. Paper. How many? Okay. So when I saw this transaction, I said, that's not and that the person refused. He kept talking about before he left here. it should have been frustration. Why are the person not? So the matter was unchallenged because the game abandoned, we are trying, but nobody controlled. So
how can you salvage a case like this?
That's part of my headache.
Because you cannot compare a witness to come and testify.
No, but the witness must testify. If you are there, you must. Well, what I mean is that it is part of official, negligence or insubordination or whatever. Okay. They don't have the interest of defending government thing. After it's government is.
And sometimes it's fear.
Like
this man that came to court and was saying he's not aware. He kept saying he was afraid. He kept telling me he was afraid. Before you know, it's time to pick someone else.
Let me tell you something. If we have an agent, you know, the dedication to them. I wasn't here when you were. But I heard so much about. I heard so much about. He would just call the rebuke and tell the commissioner, tell that their staff, if anything. So if you want us to coach you, we are your lawyers, but not to abandon the matter that I'm not the one to be a lawyer and also be witness.
He was pushed.
So
in fact, sir, the defense we prepared, he's the one who briefed us.
Yes,
it is not fair. It is compromise.
He's a lawyer. He was afraid.
This one, even this one I'm told is a lawyer. Even this one. So they know what they are doing. Even this one I'm told is a lawyer. They know what they are doing.
Because when I told him that statement is already before the court, I should go and look for another lawyer, another witness. How that was why he now.
So when they mention why do we have this kind of thing, some of the problems are from the FDAs caused by the people there. So if you don't think you're a lawyer, so next the incoming they brief the governor and they take a hard stand. I had to threaten one guy and I told him I was serious. When I could be very angry because I know that when eventually this thing happens, it will see all on my head. I told him I called director of lands, give me somebody, give me a name. I called the guy came to him, we discussed everything. On the day of coming to sign, he was trying to go. He said he wants to take this thing back. I called the director. I said, the matter is also if he does not sign that document, or you give me somebody immediately, he does not sign that document. I'm making a presentation through the AG to the Civil Service Commission. That is, I told him, I told the guy that either they will send you somewhere, they will remove you. I will make sure it is me that you want to frustrate. So he had to, nobody came on his own when he got that message. And he signed it. Today is okay.
And that message will work on any staff. The next month.
Against property agro gas, the day I saw it was we met in one government meeting. I mentioned the place. We had appointment here, since we are not
they never do it on their own. They don't have any particular interest. It's a message.
It is that person that send them. Send them directly. Sometimes it could they should follow. Okay, why do we have a
commission? It's always the governor or a commission that sends them. Right? It's always the governor or a commission.
If it is a commission, like one, they join its name, so but you know that when there are several government, but the message should be made very clear. Yeah. If you want to do it, be sure what you want. That's why the lawyers or technical people should give such advice before you embark. I'm just using that as an example. I'm giving you instance of those that work in local government or even here that discipline people. They should be up and
Yes.
I've talked about people conniving with, you know, and so when we handle that side, we tell ourselves, then we come to contract. Most of the contracts we have won. Job has been done. If you don't have the money, you can stagger the payment. You don't expect that. It's only in the wilderness of sin that you can bring water from you. You cannot. We do all what we are doing here. Isaac will struggle, we fight it. At the end of the day, be able to take responsibility for your liabilities. For how long do we continue? Okay. And like, for instance, the one to show me that has been intentionally created so that there will be default. Do an agreement that will bind the government in such a manner that
10 billion.
And then if the government wants to relate an incoming government that will come in and discover fault, say you cannot talk if you want to relate from it.
It's not the non-disclosure, it's a substantive agreement. It's not one agreement. 10 billion.
System here by everybody not interested in government affairs. It does want. I am already sat down to analyze the events that will happen, the one that we are already in, the one that will happen in the months to come, and all of that. The next one you see is IRS, taxes, and all of that. You will be able to verify what are the taxes. So look at those areas of how the intellectual analysis.
Yes.
So I want analysis the land, the demolition or illegal acquisition of land. Those are the things. Then the other one that has to do with non-payment of contract sum, and then if you can look at them.
So thank you for your time.
I think go and work on something. Let's see after the holiday, by June, those are around, hoping and believing that there may be money if there is no money.
Ministry of Health, that's one else. But I'm missing a request from people. If they don't bring me, what's the name? Because of the time, 3 days I'm already.
From what we have seen, that man was commissioned as a contract staff for payment. We have seen everything. It's not that they have not paid him. And then the best you can do is maybe to extract only what asking for maybe a few million, but basically we are owing.
Basically, we are owing.
They should pay him.
Basically, we are owing.
Or they might not be somebody.
I read the rules of the court. In that summary judgment, you still have to pay your defense. So we must have a statement of defense apart from disputing some.
It's not the same thing like
so my own is what will we do in the statement of defense now? If it's for the summary judgment motion alone, I think you can handle it without a break.
Once you make any commitment, of course there will be commitment. It's not the bills for the one that you have committed by saying by fire will do the one you can.
One day is the public committee.
First.
This weekend I'll see what I can do.
Is that the right answer?
I think you said Mr. Ashley very good. Mr. Ashley very good. Now my time.
We'll see all together. Yes, ma'am. Congratulations, man. Back your move on. Okay. Oh, congratulations. I live here now. Give me that one. She said, every day. Okay, give me that mommy. Okay. I've been here connected that. So I've been there.
I feel we have
You see that you have to find your own. I don't want anything that I don't want that kind of.
See, you can't even use your money to compare.
I don't want that kind of. Family.
If they see you, it's 100,000. Where will you come from? And who will pity you in this federal court? As they're still record, like money don't come. Do you understand? Or who will even answer you for that? That is their money. Just among the percent they are respondents. Without that, it's easier to be a respondent. So it's only brief you will find. Brief or PO. She done. Yeah, I'm always tapping on that thing. That particular thing. I'm hungry. You want to come out straight for me. Come on, you come out to be after you. Right.
Oh, I don't know if they cleaned it yesterday.
So messy.
Water has gone in and there's she's not here. But I thought I used to come to drop you so I don't by myself ever. Yeah, I'll never drop. I don't like. I can't do it. When I drop it to waste, to pour everywhere. It's not even inside the eye. No man, it's good. Yes, bring it out, pour out. I don't like. Okay. Sorry, ma'am. And it's not coming from your glasses. No. Like after I close now, it's just a while. Okay. Sorry. Glasses are not happening. Okay. Sorry. My own. I never take your own. It is getting me correct. No, I won't go. I got it in Lagos. No, I said you go back there. No, I will just go to to hard at the time. No, that crowd there. Maybe hospital here. Okay, now the day I want to go, I know that I will eat well. Go early. I tire. Like the last time I went early, and I don't know whether it was money they wanted from me. We can't find your folder. We can't find your folder. I see people that came like 2 hours after I was there. They went to the opening my wallet for that item, then I go to other department, other examinations. Now, I said, my last year was public sector, I don't know. After a long time, people that passed me, but people that didn't pass, say she are not seeing my phone. Say that they say, oh, I'm supposed to book waiting. That since my as I did my clinic was Wednesday, I got looking my card the Wednesday. So no reason would I come on Thursday, and the day I went again was on a Thursday. So since I came to the store, nobody will attend to me. I have to book again. Another Wednesday. I myself went to see the folder before I go. Then I said, no, let me take a look at it. I left. So she has that man that told us to go to the meeting so that the next will be easier for me. I followed that woman, I left. Hello? Hello? Yeah, so now, I like it. That's nice. No, I need to reject call. Maybe if I don't pick, maybe I will not available. Why do I pick this one? If I don't reject call, who am I? To reject any number. Anyone I see, I pick it. Sorry. I've not checked. You're
What happened to me yesterday? I was very happy. All I was thinking is just quickly. She was already coming towards me. I just came out without my shoes on. I'm not to pick. I was running out. I removed this so scared. No more slippers. I really went to pee distress free. And now came back. Still with the camera. Like, okay, this comes on. Now forever. This one.
So she knew that. No, that is.
She will not be looking at her clothes. She will not be looking at your face.
Oh, okay. She don't be looking at her.
She will just see her.
Okay, she won't say anything.
No comment.
No comment. I didn't think was on top there. They were having a comment. Did she say
She did not make any comment. That was my look. And she did not even give me that look. But I was just saying. I was not telling them later, see what I do. I walk around my school and I know what to say. So I ran like, did you remove the suit in the car? Like, why did it occur to me to remove it in the car? It did not even occur to me to I was rather thinking about it.
It's true.
It's
It is in the car. You would have taken
just
it.
removed it. Come on, normally. If you see me,
You know, children think.
Yeah.
It's not those that can wear their mother's clothes. My mother, you can. There was something there was one bag I wanted to use. So I don't remember whether I didn't mention it, I don't know. So she now came and said, that's the bag. I don't wear your shoes. I don't wear your clothes. If it is this bag that I want to use, it is what I will use today. Find another bag. So I take it back. I said, I was struggling this one because what I said, will cover. So I went to the doctor, you know, to don't enter.
I have missed him, haven't I?
Oh,
He's coming back. It's Friday. So you don't like that. No.
Don't stop. Anytime you saw that she likes, you pick. They share the same thing. I don't do it.
You wear my dad. Yeah, it's true. So when you want to use the perspective and raise a food like that.
Since we cannot share, we don't share. They should carry my brooches. I must carry something. I must carry.
Yeah, when I was there,
so she too has elder sister. Yeah, she can carry mine.
But my mom has even reduced. That's why her things are sizing. She has reduced me a bit. Yeah, she had the same.
She will snap picture and come and post. You will say, I've been looking for that now. My mother took a single picture that was so fine. See, you started to make up with my week. But you have to come and beg my mother. You go and beg her now. Tell her to that. Me, I don't carry anybody.
Oh, you are for me, elder sister. It's true.
Yeah.
Big one now.
We don't share. But what they do, some of those.
But they take your things.
Yeah, the shoes I buy that are not exactly my size. Maybe slightly bigger. You need to wear shoes that they'll carry. Or when I bring shoes, it's because I do that one. I will bring shoes. She first put leg. Once she puts leg, my own leg will not be able to leg again. She will carry. I will sew a dress. Somebody will come and wear. Come and tell me, please see, it's tight and me.
It's your clothes.
I sew my dress myself. Come and carry and wear. It's
like
she did not say so that they can move. I should put allowance when I'm sewing it, I make it bigger. Okay. So that it can be okay for them.
Yeah.
Among them, I used to just see the
laughing.
How do you borrow? Somebody will go and borrow another person's trouser. Lead you when she went and carried your trouser and she fit it. How do you borrow somebody's trouser? Then when she wants to wear, she will first take it the night before to check whether they are fit. She will now loosen it. When she wants to wear it,
and the machine is working.
Blouses. How do you borrow somebody's thing and shape it? Then my mom will tell me, try to be putting allowance. You see, when I wear it, there's a way it is. I don't like it.
Your body is coming. Your rib, but this is big one. You know Jennifer in IRS. I should tell her now. She's just starting. Jennifer, the smallest one that's following.
I know Jennifer.
I've seen her now. Your body is coming.
Did you see my father?
Because don't worry, I've seen your legs. That's all I need to see.
They used to tell me that in those days.
If you have big legs,
I was very tiny. I more than
your body has come out. She's tiny.
But can you call it as long as I have fat legs?
Your body will join it.
But can you call it an elephant?
Actually, no.
I'm fat. Actually, you are not fat. You can fat like this. That's what I'm saying. You can't call her fat.
We are here now. Yeah, that's argue.
How many children does she have?
I know they argue.
See,
my children. How old is your last child? What are we talking?
So what do you mean?
That's what I'm saying.
What do you mean?
That childbearing age, your body will be later, all those things will go away. Yes. Later they will go back. You may even come back to this body. If you want to come back, you can. Or you need to think that it's your body. And this weekend I'm going to Calabar.
The next time you want to pay again, you want to.
No, my son has taught me. I'll remove it. I'll catch you on the road. As I'm standing here now, if I sing another, I will hide. That's what I was telling her. Is it not you? I know that she'll do everything for me. If I see her, I will hide. Not see her. You just somebody looking at you. You're not saying this. And that look is not a funny look. It's a look that you don't want to experience.
How is better? I like okay. Not about I've been doing for.
No, she'll be back.
Okay.
Which I don't use the ATM. I don't know if I need money.
It's your student frequent bank. I didn't sometimes I'll feel like this, I will not have any money. What's the problem? I don't see how I carry myself and I will just be broke and moving like that.
You have that girl by your house that gives you money.
I don't know. So therefore, especially with this kind of song. So can make people crazy.
Your mind has gone around your house. You have done the math. There's food that you eat. There's friend in your car. No, that's for a different topic.
My point is, I'll calculate it all.
So nice. I don't know. ATM.
Okay.
Yesterday was that
she needs to get inside. I'm not in my car out there. My car is not I know.
No matter what, I'm making it which matter? That matter I told you about our flat came out. Okay, in our estate. When they stood, I now realized that last year, they put up the houses in estate for sale. Before now, there have been no approval to sell those houses. Only our own, me and that Mrs. Aleka's one. It's as we bought that everybody's now open that they can buy their house.
So, but yours is not all those put up for sale.
That's what I don't know. And I don't believe.
Please go and find out because you know those notices are public.
Right?
You can't come and say you are not.
No, they're supposed to sell me personally. This is selling personally.
Let me get and say this. There's water.
The man that is doing now, they came to start with any property. After putting it up. How is the toilet? 8 minutes.
There's water.
Oh. Mommy, are you okay? How's my voice like? Okay. Sorry, now that I'm finishing. Okay, right. You called me. You lost them. One more time, National Industrial Code. That ITM will get my. I told you that one have that I made up. And maybe to tell you that if we need to have right here, your ITM work. Let's have fire. At least discipline, how to discipline your employees. So, it's not our fault. It's the way that it's the way that it's engaged in their staff. They do not follow the terms and conditions of the employment. So there's nothing we can do. We try to put up in place that is not statutory, because that is employment not protected by statute. When they cut now, so it's our cases are not good. Now, this is a ministry of justice. Yes. Like this man, for that of us, it came up today. Came up today. Like they are not going to speak in the house. So then they are going to go and attend an injunction. National industrial court. Living there at this with charities and you know that house. All types of people are living there. They are sold that house. And it is still this official course. Does not live with but it are located to me, he puts his family and all manner of people. And I'm sure it's the way he left the house in the very fast. If you are just managing small, they'll know it will fix something. They know that it's not going. So he's trying to fight now because he wants to buy the house. But they're going to sell it to another person. That one came up for that section. No, it's just an there. They took the application and we got attorney for it. They got to rule on whether it will stop the people or not. But continuing any engagement plan while they're still. Okay. 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 We drop to 1 million. Yeah. What's that? I'm sure seriousness. And renovated it to that point exactly because of the state. When I didn't go inside the car that they gave the other people for 5 minutes. But if there was no block standing on his house, no nothing else. Very bad state, so you now go and value the same without their 5 minutes. 5 minutes. I know. Because that period at that time was 8 million. So I wonder. Meanwhile, they valued our own for renovation first. That was what made the money to reduce. I still have some things to do. I still have some things to do. I give back a video. Of the reaching. Whoever she is. So they are there in the house this morning. So I gave her this morning. Mommy. And see, you see all this. My parents don't see any fault. Wait, you'll be here. It will happen. When I look at them, you will see the whole. You will see the names of the family. You will see how I will cry. It's something that will show you. They don't see any fault in anything that they do. The family is doing great. What's that? The Beatrice. Where is the name? No, the one is not that way. I've never seen them. That car that they went to buy called me. That one that looks like one Honda. I don't know. That was high. Looks like that I was dressed very well. Looks like a car that will give them serious. It was not shining, but it was great. And no. But before you remove them, if you know that don't work, why don't you tell about I said before you remove them, that's when you are ready. Instead of just like remove them, I'm going to make sure like it's like this. I want to put like nearby and thinking. So you just put rent and noise. I even know that I can wait. Because I know that waking up and it's not this. Okay, that's how my daddy used to ask me whether it's happening. I know them, they enjoy the children, they have to be married. They eat the children, they enjoy them like food. Now look like you're coming to remove our enjoyment. How to close this by one? Where does it stay by from 1 to 3 when I come close? Grandpa's. My point is your internet will not be happy, so it's good to say something first, not just like rather don't like something like it has happened today. Yeah, so you will have these children now. Wow, they stress you people. You know, you start saying things like that. Rather than complain, like rather I'm sorry. You see, I know that this thing is not easy for you people to do. You understand? Come from that, rather than from how you see. Come from how you feel it affects them. And apologize today, but you see this thing I'm doing, you see that I'm not angry. It's because I have wasted all my anger and no results. What's now? I'm now come as this me now is a non-reaction now. But I pick up my mind and wait. See what life is going to be. You don't just wake up and make up your mind. And then start now. To say, I feel bad when this thing has to stress people like this. So I know it's not your intention that this students do, but it's not easy for you to meet up with. Something like that from an understanding point of view. When you make those type of comments, then finally when you want to do, you also seem like, oh, I don't like all of this. So I'm looking at it from stresses. Before I leave them in the house, I leave secrets of instruction and warnings. They are just left the house. Because Michelle, their hearing is one of parents. You have to repeat this every time. And I'll be like, you did not tell me. One of the one that told me yesterday. Like, oh, those children are so sad. I'm so disappointed. My mouth was crying a lot this morning. I'm staying in the house. I don't make them share the story across. If she's the mother, I think she's those mothers that just maybe because now I'm child. Michelle, the girl that is
She's not the one that is also in school.
one that's all, she will not go to school.
You say she's a mother, and wondering how old is she?
She's 17.
Okay.
I believe she's the mother. She's those mothers that will just right when you're tired stuff. But when you're tired stuff. Just be there, don't stress it.
So don't be angry. You know that they are very online. Don't ever be angry anyway. Don't be angry. Tell her it's sympathetic towards those who do not come and so by the time you take that decision, your mom. Okay. When you went to like,
No, I've made it in 3 different systems. I think the last 2 weeks I made was December.
what do you want to pay? What do you want to pay?
Today is already.
So what? Oh, okay. Okay. Transfer. The judgment you are looking for must it be all that you have done?
I know the ones that like this one with
I was sure that because I agree that you want to face. Yes, I was sure of that one, but I also should I told you that on some ground, like that one of your notice. I was not sure how if the man did not come and collect his check, why did you transfer the money to him? Saying that he has refused, why did you keep it? And I felt that what we should have done that the stop check because I just check come give me. I guess it's a photocopy of the check. Yes. Can I not? If you show me on check, I can see that after you got this one, there are 20 others, there are 30 others. That's when I will believe you. So that's what that was another factor. There is always you should put it in forward.
But you not consider whether it goes whether you
so if you feel like one of the case for me.
The mark actually has many answers. Now maybe I will compensate to the one of that.
I saw this case as one where having effect without work, where it's like saying it's a where nothing the body got judgment. He said both of them did not put their case. The body got you don't be a good.
Like I said,
no, I didn't clean. I went. I actually used my toilet anymore. And I don't see everyone.
Our own toilets are very one. It's their private toilets.
You don't have to. It's still my ex so does he have name? My mother. I just said it because I wanted to do something. No, you just talk of something and now I was very interested. You know spinach. Why leaves, ribs. It's a nice.
It grows locally. So what we call fruited pumpkin.
Oh, because we don't have it. Slide color.
It's not just our pumpkin. There's one other vegetable that they call pumpkin. Do you know?
Yeah.
It grows, it creeps, it fills the whole place. Let's sell it in spot. It's just finished. Where did you buy it?
Because the garlic soup you wanted to cook, my water leaf has kind of died. So you have to, if that water leaf really works, so you have to look. No problem. You should use that. So it's not so bitter. I plucked the sweet one. It's the sweet when immediately I came and started. I'm not even tested to be affected with. Is the sweet one? You started the sweet and you got that's bitter. And you that sweet. Then you now pack plenty
Spinach.
dawa.
You don't eat that.
It's not small, you put it.
Yeah.
He was to say,
To show you.
She just said, it's because of you. It's because of you. If I was eating this thing alone, I would have put plenty dawa. It's because of you that I reduced. I don't look at that. So I said, please, mommy, let's put plenty. Let's see what will pay. I said, I probably want this to put the quantity you wanted to put. That's dawa is everything. Now it's because of you. What do you call that? I just said to myself, then if you want to
Spinach that when people buy abroad, they use it to cook their after, right?
Yeah.
In place of water.
Yes. That's spinach. Many people call greens spinach. Greens is one. Sure, you know greens now. Yeah, this one creeps. The leaves are thick.
Okay. And they're raw.
No. They are broad. They are broad.
We use snap it and show.
Okay.
I have a vegetable in my house.
But when you pluck it, it dehydrates it. Well, first you market. Now I hope I'll meet that goat meat.
Yeah, what vegetables is there? No.
I don't say I don't do that. It's actually Thank you for today. What did I do? You should be.
I won't be there.
It's clean, though.
I don't want to be the one to go and see things.
No, I see it's clean.
Yeah.
I didn't use my own. When I saw water in my own.
Okay.
Hold on, sir. Sir,
Yes.
will you give me 4 days casualty?
Okay.
Okay.
No, that's what I mean. There's no issue. I'll look for you.
Okay, sir.
From next week.
Sir, yes, sir, next week.
Voila.
Okay, so let me tell you, I have some things I want to sort out. I cannot come and
No, don't worry. Yeah. There's anything I need to call you.
Okay, sir. Thank you very much, sir. Okay, sir. Thank you, sir. Happy weekend. Hold on. No problem. This one is my gown now.
Why did I even put my own? I want to remove my mattress.
I'll drop my own. I'll carry it. Are you ready? Don't worry.
There's a laptop in there.
And I'll stand up.
You can sit down.
It's just how you started charging.
Just now, just 5 minutes.
Okay. So you are going now.
Yes. I look at my phone.
Some of the people that I bought for my sister. That's what she asked me to send to her.
Yeah,
they are downstairs. Then I'll come back for the tablets. Mr. Monday, I greet you, sir. Welcome. Good afternoon, sir. Fine, thank you.
Everything on Monday. Monday,
Endurance is back. I guess how? Where he parks? Oh my. Oh, that means you the other side. No, I went to pick now for her. But the market now. Yes, yes.
Wow.
I just wanted you to see.
I'm already imagining this. I thought you have one. A blue version.
Now, wow, this.
Come close that door. Close that door.
Where will I?
Close the door first. Not on the door. It's sunny. Sun has
Sit
come.
down now. Come inside.
Okay.
At least. She said,
Your sister will just buy clothes.
no, she has people that she makes for.
Okay. Your sister in Lagos.
No.
In PH.
Yeah, the one in Lagos and also.
Okay, so
Okay, everybody shows except that one, except Lagos and mommy.
big one. How you they take this material?
I take time, I will just sit down, pick them. So for in her own case now, I will.
I've seen this in black before, and the styles that I've seen them making
Always
always for their beautiful.
I just wanted to show you.
They are really eye-catching. In that your
And this is dress, that dress I wore
I
yesterday.
love this one. Oh my god. Why do I love this one like this?
Fine.
The color
I
very
want
calm.
to. I should still be able to send them today. Maybe I should send first thing tomorrow morning.
This material and she bought it.
This one.
I tell you the truth.
This time, I think I have time. I can make things like that.
A round neck suit. Round neck, no collar. Short sleeve. Those kind of hands that I have.
Okay.
My mother has this thing. And she bought it. So I'm wondering how the material is.
It's a sample. It's a sample.
Fine.
All these ones. That's that one endurance is fair. Is fitting. Do you like this one?
I love it. I love it. Wedding dress.
This is the first. That's the first time I've seen endurance with that one.
Okay, she'll just make for you, then bill you for both the dress and the material. Okay.
Yes. She doesn't even like, she has a mannequin. She
ready to use.
Ready, yeah. She will just put it there and people will just indicate interest and they will just buy.
Wow.
Then some people will come and you can bring it out if you want to. I just wanted to show you.
They are fine. They are too fine.
This one and my mom.
People are trying to.
They're arguing. The one I got.
The back of which one?
The guy told me it's 2 ways, but I felt this is. This looks like the front for me. Let's see this one. Then why is it folding like this?
Depends on what you want to do. And you can in the style you can use the 2 parts.
The guy was like, so she will be the one to choose.
In one style you can use it.
There's one that I got was very nice. I wanted to take 2 yards. It was just 5 yards left. I wanted to take 3 yards for myself and give her the 3 yards. Only for me to reach the house, and my mom is like, she wants that one. The way I'm seeing here, are you sure I'll be able to send this thing again today?
Well, how do you send them? Which part?
No, I used to send through calculus, but she said that I should.
These are wedding clothes. Nonsense clothes. Like
this guy has fine clothes, but I usually need to sit down. It's not every time I go and see what I want. I will sit down. Okay, like this time I went, I didn't see black. I didn't see black.
This one is a Nigerian. I don't know.
Yeah, no, this one is my sister that sent it to Professor.
Okay.
Sent it. My mom does. We don't need it, so we are sending it to her. Okay. She will know what parents want to do with it.
It should be for somebody's wedding.
Yes, sir.
Okay.
She sent it with my sister in Abuja. She had to buy. She knew she won't attend the wedding, but you know when you don't buy it, so she bought. She doesn't want. Because she sent it with the Ashoke, but we are not sending the car Ashoke. That girl does not buy her hair. So. I wanted to show you.
The colors.
Yes, they were not. They are not. I know. I trust her to be able to mix it. This is all that was left. I still picked it. I know that she will be able to mix it because
With
it's too
something
fine.
else, right?
Yeah, it's too fine. But this is exactly what I wore yesterday. Black.
Opening my eyes. What?
This one.
Eh.
Yeah, the dress I want to see. No, that boy, it's not the one.
Eh. Okay.
Yeah.
I was going to say, have I not seen something like this in black?
I had this blue. She's the one who came and carried it. When she came, she carried it.
Lucky sisters.
In fact,
All of them are very fine. People, why didn't you pick this one for yourself?
the ones that I picked,
Black and
office,
white.
this black and white.
You can wear it
Not
to the
black and
office.
white. Though.
It's black and white. Too.
I don't want you people to have a
Not on a cut thing now. You can wear it very well. I would say feeder women or feeder meetings. You will see things like this 1 million. That's when you know the kind of lawyer inspired. You will see all manners of black and whites. Beautiful.
I just wanted to show you.
That's fine. They're very fun. By the time they'll become dresses here.
I'm having a change of mind. I don't think I'll change an agent. Maybe tomorrow morning.
You need one urgently. Where do you take them to?
Okay, before I should send through calculus, like today she said I should send through body. They've moved.
Okay.
They've moved. So where they are now, she said God is giving better for her. So and it was later as I was about leaving the house, I now remember that lining is more expensive where she is.
You have a dress that looks like this. That Mrs. Ona said is wedding dress.
Yes.
It looks like this.
Even
right?
my mom, when she saw it, she was like,
fine.
even my mom, when she saw it, she told me, this dress looks like the other one.
Well, that one has red in it, right? It
No,
does
it's
have red. No red at
No, it's
all.
not. It's a brown. Well, sort of
Maroon.
blood, something like this.
Okay. Your wig is so clean. Do you wash it?
I don't go to. Yes, I used to wash it.
Not just clean, it's still new.
I wash. It's still new.
It's still very
I
new.
put this one. I usually wash.
And wigs are so expensive now. I don't like my own anymore.
I will not buy it. This one
Sani
I
stole
didn't
my
buy.
real wig. Then someone borrowed my white wig permanently. Sona.
Okay, the woman you showed me cut.
And that's the one that I know suits my face. But it was a cheap wig.
So this one you're telling me is a wedding dress.
Because of that, your dress. All these materials, so there's no place you cannot wear them.
I know, but you know, all advertising wedding.
Because of that, your dress.
Then this one was another one where I made. Which one is back? Which one is front?
The big steps. Those are type of free steps. Then, this is how our guys go. And if a lady appears like that, it will look like one. It's like we were the ones who wear Ankara, the ones who wear jeans and t-shirts.
You know, now when you say woman, everything will be outside. Everything will be outside.
They are beautiful. This blue is actually fine as blue, rather than black. This one is so
I don't like I picked it. I don't feel that she like it. Oh. My mother does not do business. This one is your mother. You guys even write business. You don't have a shop.
We had the shop.
What happened to the shop?
Rented them out. Then the shop where we were selling in the shop. Fabrics like this.
Yeah.
All those things I used to tell you, I carried it from the house.
Okay.
It's remaining one from many years back.
Okay.
Those things are more than 10 years old, though. Those things I'm making now. Remaining things from the shop that she refused to.
What kind of fabric? Sample or
sample laces, then Ankara. Even English materials.
So why did she stop?
Other things.
Then she sold the shop.
No, the shop is still there. on rent. Renting them.
Where is that?
Mariam Market. We've never rented it before.
Oh, okay.
Like 4 shops in Mariam Market.
How did she get there?
In the market, you don't have to be expanded. We were there for a long time. All my holidays in secondary school. I spent them in the shop.
Wow. All 4 shops.
No,
You
the 2 opposites each other. These are the only ones we ran. The rest were always on rents. It's because things were difficult. My mom did everything. My mom is a hard worker.
No matter how difficult things were for you, you not have been as bad as it was for us.
My mother was a civil servant like any civil servant. But she had to do many things. My dad was never. Now my dad is doing well. My daddy did not do well for a long time. That's why I'm not patient with my husband. I used to ask myself whether it's a cycle that she keeps in itself. And my father's one, the difference is you could see him trying to do things that were not just working. There's a man that has ideas and tries. People just cheating, still not know whether it's village people, whether it's bushcraft, I just don't know. You put certain things that just don't work. Some are too grandiose. Some my mom, you tell him this thing you're doing. This is what this person will do. This is how it should go. He will still try. But things did not work out for a long time. Basically, struck food, child, and all those separate things. I don't know where she's from. And she works in where did we go to go and do?
I think I've seen her before in Susanna's office.
I
think I've seen her before in Susanna's office. She came to give her.
Suits, shoes, slippers.
Wow.
Same way my mama knows.
Oh.
One time we even had a sewing shop. We sold in front of our house. That woman, there's nothing she did not do. 4 children going to school at the same time with salary of how much? Salary of how much? And the basic things, you know how their salaries are very poor.
Yeah.
One time started doing NGO. I think it's when the NGO started having a freeze and we started having funding. That's when the sales reduced. But shame now entered. Sending from place to place, people will be laughing at you. So stressful.
Okay, sir.
But the only one that is you see my mommy in Aba.
Oh, so she used to go herself.
My mommy, if you see my mommy in Aba, you will not believe that she has 1 naira. She will be worse than the market people. Her colleague saw her in the market and passed. She saw the man, she recognized the man very well. My mommy was just smiling sheepishly in the market. Mommy, why you this smile? She was just walking fast. Her speed in the market. Because if you don't leave the market before 1 o'clock, before 2 o'clock, you may not come back to Calabar.
Okay.
Because of hold on.
Okay.
1 o'clock must not meet you in the market. And that's the same day you arrive in the market.
She will go same day, come back same day.
Come back same day.
Wow.
Please come back like 10, 11, 12, depending on the road. We leave before 6 o'clock. Before 9, you're in the market when the road was good. We get to the market before 9. Fight between that 9 and 1 o'clock, 2 o'clock. We must leave late 2 o'clock. Why is not fight? Because of hold on. Bad roads. That's always been bad.
You
me, I'll be fine in the back. It's when she'll stop somewhere to buy. That's when I'll catch up with them. And the woman does not look back to see whether I'm missing. She knew. I think of this thing. Oh, my husband. She does not look back to know whether I'm following. Your mother will not look back.
She has
Sometimes
confidence.
you meet someone. Where did she enter? You now look left. She's not there. You now look like, okay, see her there.
She has that one is confidence now. That's a lot of sacrifice. This is that one I remember.
Well, now I'm not selling anything.
This is that one I remember.
Can't forget. That's why we forgive her. My mommy has unforgivable excesses.
But
like
remember,
unforgivable. But when you remember all those things,
and that it was all for the sake of her children.
Yes.
I remember that
Some
one.
mothers would have been lazy and sent their children to sell, suffer, expose them to all sorts
Yeah.
of risk.
Which were, I'm not sure how it was with you. I'm sure no matter how it was with you, it could not have been
It
as
was
bad.
hard.
Yeah.
You know what we used to eat? Cocoyam without oil. Like there will be, at least there will be cocoyam that will eat white and fill our tummy. But no oil, no palm oil to even dip it in.
Don't worry. Cannot be one
Guinea corn was our rice. Does anybody eat guinea corn? I don't know who taught her how to eat all those things. Well, the thing I'll fill the pot and do pepper and oil stew. Eat guinea corn. Me, I believe I'm short because of that shit.
Hey, coach.
See, I cannot eat back till today. From that time till today. I would rather be hungry than eat food that has one kind of taste in my mouth. It was not right. I just can't eat it. Then warm food, if I eat it, I'm going straight to the toilet. So I'll avoid it. That's how my brothers will be eating. Me, I'll be there looking for food that is suitable. Now look at me. Look at me on the ground. Look at where they are.
So remember that anyway, you see, it's all those considerations that
It's
make
all
it-
those things. So
all those
if
are all
you also deal with you like
sacrifices.
this, if you also deal with our sons, you can disown her. But when you remember,
Yeah,
you leave her.
it's a big sacrifices you make from people.
You must try.
So like this school you're talking about, think about her too, so that you don't
It's
make
my
her feel
children I
bad.
want to prioritize.
I know, but
I have
you know,
to
but you get
prioritize.
where me I'm coming
I
from.
know.
Don't make it seem like I bet I'm not doing
Because
this.
you don't think it's even easier for me for them to be there. I don't want to be an irresponsible mother.
I understand.
And then I want to blame myself for their inadequacies. Right now, I am irresponsible. They are part of, when I see some things, I want to blame them. But it's not their responsibility to raise my children for me. If their father is weak, it's my responsibility to step up to the plate. I'm the one that married me. It's not their responsibility. I don't even know how easy it will be, but God knows I am praying. Like I pray about it. It has been on the front burner.
About change this school.
Yes, and how I will even survive what I'm about to do. I did it before. The house was close to us, but this our entire environment, there's no school there my children can go. So it's not, and then okay, when I'm going home, I'll just pick them. And then we go home. We'll still take another taxi, but it's just that same with 5 minutes we are home.
Draw up a financial plan.
I will.
Draw up a realistic financial plan and how you want.
I'll have a school fee budget, even a payment plan. The fees now say we don't need to pay at once.
Because
the payment plan that will stick with.
Yeah. Jesus said, who is it that wants to build a house? You not first sit down and calculate. So you not come back to where maybe you needed, you need to now go back there.
The only reason we went back was because my salary stopped. They have always had that school, but I never wanted my children, my parents to be the one responsible. Look at this one going there. Have you seen her?
Was that her?
She's a woman of easy virtue.
Oh, wow.
Age does not change. So what do I even say?
It's just to make provisions for it. Just plan how you start saving.
There's a learning environment I want to see my children that will make me happy. Like Gamma for now, there's a school for me. Every time I have a friend whose children are in that school, she's always posting it. See, school now is not so far. ABC 1, 2, 3. It's play and learn.
Yeah.
And as they are playing, they learn better than that street learn. Yes. So there's a school for this my play Marvel that is not behaving like somebody that even wants to write.
Please, that child is too young.
I know. I'm not just. They'll be okay. Who will they come and be the like? That's what I used to ask. Who will they come and be the
Did they say that they are doing?
No. If I complain about anything, I tell me leave it. Leave them. Who will they come and be all like?
This, but now when we're growing up, we used to look at her as maybe she has the doll.
Okay.
The doll. Not that
smart
she
in comparison.
That girl is smarter than me.
Yeah, I know. Like I know those things.
She's smarter than me. This love, she understand. So I don't.
But she is a lawyer.
Yeah.
Okay. The one in Bethel.
Yes.
Bethel Bishop.
He's a smart lawyer.
I know.
Okay. This is why I wanted to be sure. I just want to be sure that I can make the right choice. They are beautiful. No, I wanted to be sure that somebody likes
Picture them as different
what I
styles.
picked. No, she's a fashionista. Amongst all my sisters, I'm the least. I can't even say the least Spanish. That woman, since the regime, I've not even gone there. That banana woman.
Your tab is upstairs.
I am coming home. I'm even surprised at that.
Endurance.
She's a very nice lady.
Just taking her steps.
She's a very nice lady.
Endurance. Okay.
And don't say that I'm not wise, not the one person. But the ones that approach this logical, rational decisions. It's a thing I find myself.
Mustafa, hold your side. You want it. Why are you winking at me? Endurance.
You notice
You're not well.
Wait, oh, even with that, you please no need to just the money.
Endurance, please. I came to ask you.
Oh,
Did you remember? Did you remember to ask your husband? That the pastor.
Yes, yes.
What did he say?
And I was like, in fact, because of you, because I love you. Because now looking like I was a child that was following his master well, you know.
I don't understand.
And like, yes, like he's surprised that I've been paying attention.
Is that thing too high? It's the first time I'm seeing one. Yeah.
It's like the first time I'm going to. Just watching yourself, I don't talk to
And yeah, stop. I want to go.
You know the time we spread it, they say the way to get power. See, I don't think this is no longer instrument.
Yes. I want to go to the market. I don't know. I'll still meet go to meet.
Oh my God, market.
No, I got my customer. He has good goods. I don't buy goods. Yeah, people. I don't know. That's what she buys. The guys go to market. No, Mariam.
I think that's the part of you I still don't understand.
Oh.
See, the office and your house. First, I'm going to marry a house.
Mariam has sanity. It's the most same place to shop.
You can never find your Mariam except my sister.
You go to what?
All the time.
You go to what market all the way? No.
Not all the way. I never leave my house to go to any market. I always go to market from the office. So see what here straight. Do you understand? No, I have to turn. What is straight? Then I come back. I don't feel like it's closer.
Oh, see, I can drive.
Some days of no driving.
Maybe. Yeah, straight. Yeah, because see, I can come here now. You have just and I can and like at least I have a relationship with that parking lot attendant.
Oh, that's the worst part. I fear that they are parking lot because as you're coming back, in fact, last time that I went to that was people and my sister first. Not serious now.
Okay. He wasn't okay.
Hello?
Okay.
So the person that helped me pack.
That tall guy. What or Mariam?
No, Mariam.
Okay, if it's what? Those people are just after their 100 naira.
You know those streets that you pass Mariam Market? Those streets.
On which side? I enter from Atekon. And park on that road. You know the where those Akpabu women stay?
Okay.
That road, that's where I park.
Like the road as if you are going to come out of this road, PM road. As in, you know Mariam Market and the Echo Bank.
I know that I don't reach that.
See, he leaves the Mariam Market and goes to a street or two after the market entirely. So even if you're carrying load, you have to trek a lot.
No
then
way.
it is what? He parks by Spa, which is terrible. But if you are begged him enough, you park by you know this is made them park now.
Yeah.
Opposite made them park. Where they should take pictures.
Yeah.
That's where you park. And you trek from there. So I used to complain a lot.
Okay.
You end up being tired before even reaching the market. You say does not want to spoil the car. So whenever I'm looking, you will say we should try. The first time so to try to park inside what market. Coming out, the case crash. In fact, we are even successfully one together was the patient. Now the distance was like 1 week because there's a side that is blocked. So you enter to the outgoing. Enter to the outgoing. Of coming out.